All set.
Okay, thank you, Madam Clerk. Good afternoon. Hold on. Thank you for that moment of indulgence, all. I would like to open up this afternoon's public hearing of the Commerce Committee, this being Thursday, March 18th at 12:09. We have 3 bills before us. And so without further ado, if my colleagues, Representative Simmons, Senator Martin, Representative Buckby have comments at this point?
Let's hear from the people.
Thank you, sir. Okay, seeing none, I would like to call our first member to testify, and that is none other than the Secretary of State, Denise Merrill. Secretary Merrill has a pressing time frame, and so we're appreciative of the indulgence to call her first. Madam Secretary.
Thank you very much, Madam Chair. Am I on? I think I'm on.
You are on. Yes,
okay. Let's see. Oh, there I am in my office, as you can see.
Yes.
Good afternoon. Thank you so much for allowing me to testify in a timely way. I do have another public engagement at 12:30, so I will be brief, but thank you very much for hearing our testimony today. I am here to testify on House Bill 6604, an act adopting the revised Uniform Law on Notarial Acts. Let me just say, at the outset, the reason I asked to come and introduce the working group that's been working on this issue for a number of years now is because I think it's an opportunity for us to say we should all be proud of how far our state has come in driving efficiency into state in business services over the last decade, which will help make Connecticut more competitive economically in the future. And I would first of all like to thank this committee for some of the work we have done on this progress. I think our office has been part of it. Over the last 10 years, we have placed almost every service online in our office, bringing in new technologies, and it has dramatically streamlined the way businesses and consumers can interact with state government. So most of our services now are online, particularly in the business services division. So I would just say the proposal before you today is one more step down that path. Passage of this bill allows for formation of remote online notarization, which will again streamline the way we do business in the state. It does this by adopting a version of Rulona, and at the risk of using too many acronyms, I will explain what Rulona is basically, and then I am going to ask your indulgence to call on some of the people who have been on this working group that my office formed in the last year to work on this issue, and they will be able to answer much more in depth any questions you might have about Rulona, which is the revised Uniform Law on Notarial Acts. Adopting Rulona in Connecticut will follow a strong national trend. According to the Uniform Law Commission, 18 states have already fully adopted Rulona, and it is proposed in another 6 states, including Connecticut. 27 states have laws that allow some form of remote online notarization. And I will say, in my role as chair of the National Association of Secretaries of State, had a committee on business services. We have studied this issue extensively now for over a decade. And so my interest in this grows out of that work. And I know that this is much further along in many other states. And that's part of the reason I wanted to talk to you about this today. And of course, after COVID came along last year, this really raised to another level, because we know that we had to do some form of remote notarization in order to get through the situation we had with COVID. And so through an executive order of the governor, we did allow remote notarization this last year during COVID. And I have to say, we have had very positive feedback. I think in some ways it's come to be expected already because it is in common practice in many states. So I would urge you consider it. I will let you know we did form a working group after last year when this issue came up. And the members included representatives from the Credit Union League, the Town Clerks Association, the Property Records Industry Association, and the Connecticut Realtors, because those groups all have interests in promoting or managing, I guess I'd say, remote notarization. And just so you know, the role of my office in notaries is we are the licensing agent, and we also provide the training, any updated training that's needed. So we keep the list, basically, of notaries in the state. So with your indulgence, I would ask if I could just kind of have you call on members of this working group. Some of them are available today to you. It'll probably streamline this public hearing as well as other things and allow them perhaps to answer your questions. So here today is the following: Mark Ladd, L-A-D-D, Property Records Industry Association; Bruce Adams from the Credit Union Association; Kathy Makeover from the Connecticut State Library; and Anna Posniak from the Connecticut Town Clerks Association. And I believe there's also a representative from the Realtors Association, which was also part of this group, available to answer questions. I don't know exactly the name of that person. And I would also, right now, with your permission, turn this over to Chris Drake, Attorney Chris Drake, who is the Director of the Business Services Division in my office. But I would just say in closing, we always talk about being competitive, but we will not be in this area unless we continue to find ways to streamline notarization. And it's already happening all around us, and we don't want to have what we used to call forum shopping. I don't know what we're calling it these days, but that sort of thing is the kind of thing that does concern me. So I urge you to consider this legislation and ask lots of questions about how it's going to be managed and exactly how it will work in Connecticut. But some form of this should be adopted this year. So thank you very much, Madam Chair. And I would ask if we could open this to the panel.
Yeah, thank you, Madam Secretary. And I first of all want to recognize on behalf of our committee that has been working on this, your leadership in this for actually a number of years. And yes, it was the pandemic that really kind of flipped the switch on this. And I think in this case, demonstrated the fact that what we had been talking about was indeed very important. But let me just quickly ask you, so your working group has concluded, Secretary Merrill?
Well, they're still meeting because there were many issues that we went over. But yes, they're still organized. I think this legislation is the result of their work, basically. So.
Okay. And then that working group, was there any representative on there from the Connecticut Real Estate Bar?
I think I'd turn that over to Chris Drake for an answer. There were members that kind of came and went. We invited, I think, an even bigger group. The four people I'm mentioning today are just part of the working group. So I'll ask Chris if he could illuminate that answer, because I'm not sure. I know there were members, for example, from the Bar Association originally on the group. I don't know if they continued meeting because this has been going on for quite some time. So
Truly.
If I could ask Chris to respond.
And one last comment I wanted to make, Chris, pardon me if I might, is that, yes, you are indeed correct, Madam Secretary, that the Connecticut Realtors were very involved, and we do have a member representing them today. That's Carol Christensen, who is, I think, stepping in for Tammy Fellinson. And so we'll have them be part of this discussion in this panel. Okay, thank you, Secretary Merrill. great to see you and looking forward to getting to see everybody in person. Thank you.
Yes.
And so,
Thank you very much, Senator.
so then we're going to start with, I guess, well, Mark, let me just interrupt here for a second. We also have signed up, first today was Representative Jason Doucette. And so before we bring our panel on, because the secretary did have a time commitment, I'm going to ask if Representative Doucette is available and ready to testify. There you are. Good afternoon, sir.
Sure. Good afternoon to you, Madam Chair. And hello, everyone. Senator Hartley, Rep. Simmons, who I haven't seen yet, but I'm sure is on. Senator Martin, Rep. Buckby, great to see you all, distinguished members of the Commerce Committee. Representative Jason Doucette, represent the 13th House District, here to testify on 6604 as well. And for those of you who were on the committee 2 years, or actually just last year, as a matter of fact, you heard from me and from Senator Gennaro Bizzarro at the time. And at that time, we were sort of wearing our hats as real estate attorneys. And I also, my practice is substantially real estate closings. I also do some estate planning as well. So I am here, and with Secretary Merrill, I would submit that we probably agree on most 99% of matters of policy and legislation. But on this one, I think we are in opposition. So I am here to testify with strong concerns on behalf of, again, other real estate lawyers like myself, and frankly, on behalf of consumers and the residents of Connecticut with concerns to 6604. So I would ask you to either reconsider this bill or to expand or form another working group, because as you heard from Secretary Merrill, there was not a strong representation from the real estate bar or the estate planning bar. And I can tell you quite frankly that members of the real estate bar and the estate planning bar have very, very strong concerns with this. And you'll hear probably from a few of them, but there's also written testimony that I know has been submitted as well in opposition to this. So I submitted written testimony. I'm not sure if it's uploaded yet. I know how those things go nowadays. So I'll kind of try to summarize. So again, I'm an active real estate closing attorney. Our small firm performed about 800 closings in 2020, which was in fact one of our busiest years ever, believe it or not. A lot of that has to do with the refinance closings. And while it is true that remote notarization provides a certain convenience, and certainly we saw that in the pandemic, our firm, and I spoke to all of my colleagues of the real estate bar in the area, did not use a single time the remote notarization process that was authorized by executive order. Instead, what we did in the height of the pandemic in meeting with our clients is that we would have a phone conference with them to go over the documents, and they would we always made the offer to do the remote process, do a FaceTime, do a Zoom. But what happened in the height of the pandemic is that most folks elected to actually still meet in person. We usually did it back last spring, April, May, in the parking lot, do a drive-through closing, so that we have gone through and reviewed the documents, and then we would actually perform the acknowledgement and notarization through the car window. They would sign the documents, give them back to us, and that was the way that most of these closings go. So let me explain why I believe that this bill needs to be revised or reconsidered. Frankly, it would be a radical change to the way documents are notarized in the state of Connecticut. And I acknowledge that the bill as it's currently drafted attempts to exempt out real estate transactions and estate planning. But I think that provision of the bill really needs to be fleshed out more, and really we should take the time to get the input from the real estate bar and the estate planning bar, because frankly, we are the people who are performing most of the acknowledgements and notarizations. Certainly there are notaries, notarizing documents that are getting executed every day. But literally, I frankly am doing it every single day in my office. I'm interacting with these people. I'm giving them legal advice. They are there because they are seeking legal advice, and we are actually taking the acknowledgement. So the fact that our real estate bar and estate planning bar was not really a substantial part of the working group, I think should cause some concern. The process of remote notarization, the issue with it fundamentally is that it has the potential to eliminate critical safeguards against fraud and undue influence. There are, in fact, safeguards within the platforms, I know, but these are brand new things, certainly to Connecticut attorneys, who are the people who are on the ground executing and notarizing these documents every day. So we really need to hit the pause button on that to know more about that. But at its worst, picture we are doing this right now over Zoom, right? I can see everyone's face in a little square. Through that square, the person taking the acknowledgement needs to determine, one, the identity of the person. Okay, so there is a way, of course, to confirm that, and I'm sure we'll hear more about that from the working group. But two, and much more difficult, has to determine whether or not there's any undue influence on that person. Okay, if there's someone else in the room, what are the circumstances, conditions under which they are there to execute the document? Are they sitting in a dark closet somewhere? And if so, why? Number three, does that person have the mental capacity? This is the most important thing before executing a document that the notary or the attorney, Commissioner of Superior Court taking it, needs to determine. Those things are exceedingly difficult to determine over a Zoom, I would submit. So not impossible, but it causes a great deal of concern. So, which is again why I think we need to hit the pause button and hear from folks who are on the ground, like myself, every day, taking these acknowledgements. Furthermore, this has the potential to encourage people to execute important legal documents without the advice of an attorney, and that would violate current law, which we passed just 2 years ago, Public Act 1988, which formalized and codified the custom that attorneys preside over real estate closings and conduct real estate closings. That has always been the case. It was firmly and finally codified in law by our vote 2 years ago. So I worry that this bill would invite violations of that. In fact, we already see, if you listen to the title companies who are on the front lines of this, we already see some violation of that. And again, that I would submit, again, the most important transactions that somebody is making, a financial transaction of purchasing a home and of executing a will. These are some of the most important documents that people execute. They should have legal representation. I'm happy to answer any questions. I look forward to hearing the other testimony from the working group. But again, I would encourage you to hit the pause button on this and to invite the real estate bar to participate, to share these concerns. And again, if for no other reason, that if we are going in this direction, the people who are responsible for taking the vast majority of all the acknowledgements in the state of Connecticut should be ready and for that step into the future. So, thank you.
Thank you, Representative Doucette, and thanks for your testimony today and also your advocacy on this. So we want a completely plenary working product on this subject and totally recognize the importance, nuances, and special situations with regard to executing of wills and purchasing of a home. And yes, you are right about the Public Act codifying attorneys presiding over real estate transactions. And so I am hearing that the real estate bar and the estate planning bar, may not have been as present through the working group as we probably would have been ideal. But nonetheless, Representative, do you not think that there is a place for this in Connecticut's landscape, recognizing really what we've just been through, and that we have, 18 other states already ahead of us on this. And in addition to that, we've got 6 or 7 that are in the queue to also ratify such changes.
No, absolutely I do. But I'll tell you a few things. Number one, as I alluded to, I frankly don't know enough about it. And as somebody who does this every day for a living in my day job, my other job, I should, this should not be something I think that we're learning about on the fly, because again, of all of the other considerations, the attorney-client relationship, the safeguards, make sure that those are adequate. And so that's fine. So we should have some form of remote notarization. We sort of got used to the idea in looking at the governor's executive order last year about how that would work. But again, the second thing I would tell you is that I don't think it will have a lot of utilization based on my experience, again, doing hundreds of real estate closings last year. It was offered to people, they elected not to do it. A home closing, again, they want, there's a lot of nervousness. They want to speak to their attorney. They want to know any issues with the title, if they have to negotiate issues with the seller at the closing table. Those kind of happen. They got to come pick up the keys. They got to bring us a check. They can certainly wire funds, but that's another electronic thing that is rife with fraud right now. So that's the other concern as well. Now, the other thing I will tell you is that something like this, and the real concern is from the attorneys is could open the door to a lot of out-of-state practitioners coming in and sort of commandeering the process of either real estate closings or will signings. So imagine it sounds wonderfully convenient to have your will signed online by clicking away on your phone and having your acknowledgement taken right on the phone. But that is no substitute for, and it's not good for consumers, certainly. It's no substitute for getting legal advice and having a relationship with an attorney. The closings, again, since there is that protection of the law, but the title companies tell us that it is still being violated. So there again, say, well, I want to buy this house, and in this hot real estate market right now, you can only imagine that you can click on your phone. And then the actual closing process could, if we extended this to its possible conclusion, could also eventually be on that as well. So you wouldn't get a chance to, again, get legal advice, ask questions about the title to your property, the mortgage documents, negotiate with the seller, have an attorney representing your interest. So it's not a road that I think we want to go down lightly without really looking at this some more.
Well, yes, thank you. And obviously your experience and expertise in this area is very important in this conversation. But as you did recognize that there is a carve out in lines 338 through 341 for wills and estate planning and the like. So
yes, and yeah. But I would like to see that fleshed out a little more and defined to coincide with the new law 1988, because there's a definition of real estate closings in there that I'm not sure it comports to this. So that would have to be fleshed out perhaps a little more.
So we would welcome any additional written input, Representative Doucette, on this specific to being more specific on those carve outs. And then you did mention the fact that this should be an open subject to continue to be worked on with a full representation on the subject, so that, we don't want to be typing on the Atwood typewriter. We want to be in the 21st century. So I think that that is the common ground for all of us. But we clearly want to do it right. It is a consumer protection issue. I am very sensitive to that. And so I appreciate your input. Are there questions from my colleagues? Yes, Senator Martin.
Thank you, Madam Chair. Hi, Representative Doucette.
Hi, Senator.
Fine. Just a few questions. I think you know my background. I'm a real estate broker, and I know that we've been using documents, signing documents through electronically for a while now, and it takes a while to get adjusted to or accustomed to. My agents are much better at it than I am, so I like the old way. But nonetheless, I hear your concerns regarding the consumer protections, the undue influence, confirming that you're actually the person in front of Zoom, so to speak, and the mental capacity aspect of it. Other than those three, what other consumer concerns would you have? Because that seems to be always surfacing, and it doesn't seem to me, particularly now that we have been using Zoom pretty regularly here, that those are not obstacles that shouldn't be too difficult to get over. Are there any other consumer concerns that where we may be missing here?
Yeah, I mean, I think certainly I agree with you that probably a high percentage of the time we could technology could try to help us with safeguards to protect individuals against those undue influence and capacity issues, but it would not be 100% of the time. It certainly would not. I think you certainly have a higher percentage of time where you'd be able to notice these things in person and observing a person, the surroundings around them, who's with them, and everything that's going on. But to answer your question, on the consumer protection front, yes, again, as I alluded to earlier, I think this has the potential, if it is carried to its full conclusion, to result in a lot of transactions happening out of state digitally, and that people would not be able to have the advice of an attorney, and the most important financial transaction of their life, buying a home, and the most important, towards the end of life, which is executing their will. So again, we could be in a situation if this continues, where your home closing is being accomplished on your phone by somebody in another state, who is using remote notarization to try to complete your closing, and is not necessarily advising you or tuned in to what's going on with your closing. So as a real estate agent, there are a lot of things that happen day of closing and leading up to closing. There are things that have to get negotiated. So imagine that if this process extends, and if we don't tie it in to 19-88, which is the attorneys conducting the closings, that you could, day of closing, have a client who has a serious concern with the title because there's a boundary line dispute with the neighbor, has a serious concern with the condition of the property, has a problem with the mortgage documents. It's not what they thought it was going to be, and they have questions about the numbers, and who do they have then at that point if it's all happening over the phone. And so that's the bigger consumer protection issue from my standpoint.
I sort of see, the capability of us using Zoom as an example here, that some of this could really be addressed. I hear your concerns about boundary lines and even closing documents, the settlement statement, and so forth. But we seem to be doing a lot of that already, and particularly in this last year. But I guess I'm looking to see what would be insurmountable for us not to get to the table in order to resolve it, because we know that it is coming. It is right in front of us. Particularly, we've got another bill on today's agenda regarding the blockchain and other technologies that are being presented to us. So, I guess if there is something really insurmountable, I guess I really wanted to hear that. But also, you mentioned that the real estate bar really weren't at the table. Were you guys invited, or were you guys decide not to show up? Because it seems
No, I'm not sure. I don't think, certainly I will, and I will, if this wasn't implied already, I'm willing to participate in the working group, or help find folks to do it. I'm not aware that there was a, who was on the working group. There may have been a representative from one of the title companies, as I understand it. But I talk regularly with the title companies and all the active attorneys in the area, and no one was represented there. So, and I will say too, to your point, this is not insurmountable, but what I'm saying is I think we need a brief pause to get the real estate attorneys and estate attorneys in the room, since these are the people who are most involved with this. Okay. And so everyone understands how it's going to work and what we're doing. So not insurmountable, but I think we're not ready yet.
one last question. How long do you think it would take to get everybody at the table and hash this out?
Well, maybe next session, I think, honestly. I know, myself, drafting bills with working groups in it, we want to be able to act on it next session. So I think we could get there if we have the right people in the room, for sure.
So is that I guess a request that we postpone it
Sure.
to one session so that you can get to the table and with an assurance to us that we will get it done?
Sure.
Okay, thank you, Madam Chair. Thank you, Representative Doucette.
Mm-hmm.
Thank you, Senator Martin. Co-Chair Simmons?
Thank you, Madam Chair, and thank you, Representative Doucette, for your testimony today. And I also want to thank the Secretary of State and her team for all your work on this, and looking forward to hearing more from you as well. And so, Rep. Doucette, I fully appreciate your points about consumer protection and wanting to make sure that individuals aren't under duress and that they're protected in this process. And so wanted to just ask, to your point about fraud and the potential for duress, have you, really seen that in your interactions, both in person and then this past year through, the ability to do this remotely? Have you seen any incidents of fraud or duress, and how common is that?
Sure. I mean, yes. I mean, every day, like I said, when you're meeting with someone in person, or even dealing with them on an ongoing basis, like in the course of doing an estate plan or a real estate closing, you get a sense of what's happening in that person's life, what their circumstances are, what the context is. Oftentimes, both on real estate transactions and on will transactions or will signings, you do have family members attending or other people. So you can get a sense, again, of who your client is, what their circumstances are, who's sort of with them in this transaction. So if there is any undue influence, then you would be able to sort of sense that. Certainly much better than if you were just taking an acknowledgement on a phone and you see somebody behind a camera. And it's funny, I don't know if anyone else saw this, just as an aside, but there was something I saw on social media of a court hearing recently where it was a domestic abuse case. And it was a court in Michigan, I believe. The prosecutor was on, the defendant was on, and the victim was on. The prosecutor asked the victim, "Where are you right now?" And she said, "Oh, I'm at a house." And it turns out, after further questioning, that she was in the same room as her abuser, who was the defendant. The police, they alerted the police. The police came and picked the guy up. His bond was revoked, and he was put back in jail. So I just, as an aside, I saw that just the other day on social media. So that's an example of how how Zoom, there are some downfalls to context of who's talking and what's going on.
Got it. Thanks for sharing that. And indeed, that is a really scary, awful situation, and I think important to point out. So I guess another question I have is kind of following up on my co-chair and ranking member's comments. What Senator Hartley said about 18 states have moved in this direction, and to Senator Martin's point, we are moving into this technological world. We've had to do it as a legislature where previously we weren't allowed to vote remotely, and now we are. And as we kind of move into the future with utilizing these technologies, do you have any recommendations on language that could enhance this bill to protect consumers from those concerns of fraud? Anything you would recommend there?
Yeah, so again, I don't know enough about how the products work, the notarization products, and we may hear more about that. So I can't really speak to that, the nuts and bolts of it. And again, I would submit that's one of the problems with moving on this bill this year, is because myself being somebody who would potentially use this every day, I should understand how it works and be able to provide some feedback on it. So there's that, but I guess what I would say was, and what's unique about Connecticut in a lot of respects, and we see this in everything that we do, that Connecticut is the land of steady habits and is very unique, and we have home rule and all of these other things that we know very well. Connecticut has always been an attorney state for closings. Certainly for wills, and most states' wills are drafted by attorneys. But in other states, particularly out west, so when we hear about the vast majority of states have moved towards this, they have a totally different closing process. It's mostly in the Northeast that you have attorney closings, which again now has been codified in law. So it is a little bit of a different transition for Connecticut, I would submit. And so to your question, I would say, we certainly should continue to carve out the real estate closings and the will signings, and continue to talk about it. And if there are advancements that we can move towards more electronic process, then we can do that. But I think we've got to do that very carefully.
Got it. Thank you for those answers and for your testimony today. Thank you, Madam Chair.
Thanks. Thank you, Caroline. Much appreciated your comments, Representative Doucette. And you talk about that example, that was just last week. I don't know if anybody saw the one which was a little bit more lighthearted, where there was a proceeding, and I think it was the counsel for the defense had a cat filter. And he was, have you seen that? Yeah,
Yes.
I mean, that went viral, where he was talking, and there was obviously the video of a cat, and he is saying, but I'm fully prepared to go forward, Your Honor. So no, there's all of that, and we get it, and are sensitive, and that's clearly why we have this carve out that was identified in line, I think it's 338. So to be continued, and I don't see any further hands raised here. If I'm missing something, Madam Clerk, correct me. But so thanks for being with us, and we will take you up on your offer of participation on this. It would be very helpful on a lot of fronts, knowing also the legislative landscape, sir.
Of course. Thank you.
Thank you. Thanks for being with us. Okay, so now we're going to proceed to our panel. And I just, Representative Doucette had been signed up first, and we just needed to accommodate Secretary Merrill. And so, Chris, my apologies here. You with us?
Yes, that's fine, Senator. So I don't have any formal remarks other than what the Secretary mentioned. Our office has submitted much more lengthy written testimony. Obviously, we had to truncate the Secretary's testimony because of Zoom and time commitments and things like that. So let me just kind of go through a couple of the things that have been brought up in opposition. I just first want to point out what the Secretary's position is on this. So we are asking the committee to adopt RULONA as we have asked for it to be amended to account for some Connecticut unique practices. The language that has been cited in lines 338 through 341, that's section 15J of the bill. That is not language that we propose, and we are asking the committee to remove it. We do not think that exempting real estate closings or wills from the area of remote notarization makes sense. We do want to sort of address a couple of the issues around real estate closings and attorneys. So there is nothing in this bill that would allow a notary public to conduct a real estate closing. In fact, there's provisions in this bill that expressly say that that's illegal, and it's a disciplinable act by our agency as the licensing agency. So attorneys would still engage in real estate closings. I want to also sort of mention that when we talk about real estate closings and attorneys executing documents in conjunction with the real estate closings, they're doing so not as notaries public. They're doing so as commissioners of the Superior Court, because there's other state laws that allow commissioners of the Superior Court to sign acknowledgements. So, you know, it's a little bit confusing here, because we have in Connecticut, we're somewhat unique in that we allow so many other officers to do notarial acts. In many other states, if you're an officer that's allowed to do a notarial act, you then have to subsequently register as a notary, even if you're an attorney or some other person. But that's not the case here in Connecticut. So that's what we're talking about in real estate closings is lawyers acting in their lawyer capacity, and in their lawyer capacity, they're allowed to do acknowledgements. Our language does apply to lawyers. It would say that if a lawyer wanted to engage in a remote online notarization, the lawyer would have to follow the rules of this bill, but it doesn't require anyone to do anything. Your traditional in-person notarization remains completely valid. And, you know, so if someone wants to do an in-person closing or an in-person notarization, that's completely doable and legal under what we have proposed. Just one last thing on safeguards and fraud. So we focused a little bit on the issue of coercion or competency, but you know, typically the things that you're looking for in fraud are impersonation, identity verification, and alteration and forgery of documents. In those two areas, remote online notarization is superior to in-person notarization. The ID safeguards in the remote notarization software are more robust. They're less easily fooled than forging a driver's license or presenting you know, some sort of identification that's not you. And once a document is digitally signed, it's nearly impossible to alter that record. And with paper records, that's not true. So there are certainly concerns, but we would posit that there are areas where remote notarization is actually better than in-person notarization. And on the issues of competence and capacity to engage in a legal transaction, I sort of would throw it back and say, I'm skeptical that there are a lot of real estate closings that are being held up right now because whoever is engaging in the closing is worried that the person doesn't understand the legal significance of what they're engaging in. But also, if put yourself in a position of a notary public, even in person, how often do you think that a notary public is able to actually make that judgment? Whether it's, you know, someone has Alzheimer's and doesn't quite understand, or someone is, you know, under the influence of a drug or something like that. It's a difficult position to put a notary public in, even if it's in person. And notaries have some training to ask clients questions to try to suss out whether or not they're doing so under duress or whether or not they have competence. But ultimately, they have to go on what the client is saying. So they ask a question: are you executing this document through your own free act and will? They would do it online or they would do it in person. And if the person says yes, in 99.9% of the cases, the notary is taking them at their word. The notary doesn't have any special mental health training or substance abuse training to understand when somebody is presenting who might not quite understand the legal significance of their actions. So you know, we do think that this will put Connecticut behind if we wait another year. 30 states already allow this. So in 30 other states, they have found their way through this thicket of real estate transactions and signing wills and codicils, and found their way to a law that allows for remote online notarization. By this time next year, it's likely to be many more. And so we will be in the handful of states that still require in-person notarization if we just don't act on it this year. I do want to mention my colleagues, because we did have a wider range of people who provided input, and some of the provisions that we've put forward in our bill are a direct result of, for instance, dealing with the Town Clerks Association intimately on things like how can one receive a paper deed and file it on the land records if that paper deed was executed remotely. So we have tinkered a bit with Rulona to provide some Connecticut answers, and I would rely on my colleague Anna Posniak from the Town Clerks Association to kind of underscore her concern in that area. But we had representatives from the financial services industry, the real estate agents industry, the Town Clerks Association, the state library. We think this is a good bill, and we think it ought to pass this year without Section 15J. Thank you.
Chris, so thanks very much. So let's, first of all, you said that there are a lot of other individuals who can do notarization in the state of Connecticut. Is there some kind, I mean, yeah, it's just people who get the credential and then are registered with the Secretary of State who can be notaries, right? I mean, for example, there's a senior living complex, which I know advertises that they have notary services. So it's just individuals like that.
So yes and no. So we license 47,000 notaries public in the state of Connecticut, and the only qualification to be a notary is that you either are a resident or have your primary business in Connecticut, and that you're 18 years or older and can pass an exam that demonstrates baseline understanding of the notary law. So yes, it's reasonably easy to become a notary in the state of Connecticut, and you do so through our office. But know in that there are other statutes that have been passed and have been on the books for a long time that permit other officers, regardless of whether they're a licensed notary public, to engage in what we would call notarial acts. So the two most common notarial acts are the acknowledgement. You are who you say you are, and you're doing it through your own free act and will, and the attestation, sometimes called a verification or affidavit. It's you are who you say you are, you're doing it through your own free act and will, and you swear that the contents of the document before you are true and accurate to the best of your knowledge. So there are other statutes that let other people do those two things. Commissioners of the Superior Court are certainly the biggest group, because those are lawyers and court clerks and other people who have been designated by state statute as commissioners of the Superior Court. But there are others. Justices of the peace are granted this authority under another state statute. Town clerks, regardless of whether they're a notary, are granted this authority under state statute. So you know, in that there's a whole nother group of people that are allowed to do things that look very similar to what a notary is asked to do. In this bill, Rulona, which is a uniform act, which many lawyers have pored over and decided that this is the best practice law for the nation. Rulona actually covers this. So they lump people into two categories: notaries public, the people that we license, or what they call notarial officers. What they define as notarial officers are people who are otherwise allowed by some other law to do a notarial act. And we have played with the definitions a little bit in our version to kind of make sure that in certain areas, we're covering all of the people that the law is allowed to do notarial acts. And so we use in some cases the definition of notarial officer where the base Rulona bill suggests using the word notary public. And that's what we try. That's what we mean is, we have our 47,000 notaries, but I mean, I'm an attorney, and many of the other people on our work group are attorneys. I don't know how many attorneys there actually are, but there's a lot more of them too. So we're talking notary publics means the 47,000 we license, but then notarial officers means them plus everyone else who's allowed to do this under some other law, including all the attorneys.
So Chris, can you respond for me to the comments about opening the door to out-of-state practitioners? I think of like Carvana, you buy your car online. So now, we are talking about having the same kind of platforms for real estate closings and executions of wills. These are obviously life events and very significant. And probably, I mean, buying a car is too, but I would say that these obviously, would be more significant on the category of prioritizing them. So,
Sure.
yeah.
So, okay. So on that issue, and I see my colleagues, so I do hope they get a chance to speak. You do have to differentiate between the practice of law and engaging in a notarial act, right? So it's still illegal, and it will always be illegal to practice law in the state of Connecticut unless you're a licensed attorney, period. So if some out-of-state lawyer wants to try to draft a Connecticut will or engage in a Connecticut real estate closing, which our law defines as the practice of law, then they're violating another law called the unauthorized practice of law. But with respect to interstate notarial acts, that's a little bit trickier. So let's take an example that doesn't have to do with wills or real estate, but a typical kind of transaction that requires notarization. So I'm applying for a student loan, right? And I need to kind of verify the financial information I'm providing to the university. It's usually, it's common practice for that type of document to be notarized because you want the person to swear that financial information is true. That's a straight notarial act, doesn't involve any sort of legal practice. It is possible that if we don't pass this law, people will go online and try to find notaries in other states to engage in that. And the companies that are offering these services online are marketing their services in just that specific way. They're saying, hey, don't worry that your notary's in Texas or in Nevada, because there's this other law, the Interstate Recognition of Notarial Acts, that requires Connecticut to recognize a notarial act done in Nevada or Texas. And so it doesn't really matter where you get your document notarized. Pop online, we'll find you a nice Texas notary, and they'll notarize it for you, and you can file with whoever you need to in Connecticut, because that's perfectly legitimate under Connecticut law. So that I do want to underscore that that's what the secretary was talking about when she says that she's worried about a little bit of forum shopping, that's completely possible today. That, if someone wants to pop online and get something notarized, they can find a Nevada a notary where, this is legal, or a Texas notary or a Florida notary, and get this thing notarized today online, and Connecticut would be required to recognize that notarization. That's aside from the area of legal practice. It's still illegal from some out-of-state lawyer to practice law in Connecticut unless they're admitted to practice law here.
So then, Chris, the the act that was cited earlier, it was what, in, I think 19, that we passed, about, I guess they called it hot powers, attorney hot powers, that the attorneys have to be doing Connecticut closings. That, in a sense, protects the, and is very important to this conversation about the concern about out-of-state practitioners.
Right. So I mean, again, I know we're kind of, it gets into the weeds here a bit, but it's really important to remember when we're talking about attorneys, we're talking about attorneys, and when we're talking about notaries, we're talking about notaries. So we, in our original draft, and I know LCO doesn't like doing this, so I'm not surprised that in this version they took it out. But in our original draft, when in the section that relates to prohibited practices of notaries public, there was already language in RULOTA that says a notary public is not allowed to engage in the practice of law unless they're a licensed attorney. And we had suggested cross-referencing that act where we said, including but not limited to engaging in a real estate closing as prohibited by, I think it's in Title 52, but you might be right about, Senator, about the cross-reference there. But the act that Representative Doucette was talking about.
Yeah.
Now LCO stripped that out because they don't like to say, like, don't do something that's already illegal. And so it's just, the way lawyers like to draft things. But yeah, we kind of wanted to hit people over the head with it and say, we're not trying to say that notaries can engage in real estate closings. It's illegal. It is still illegal, and nothing in our bill is suggesting that it should be legal.
Yeah. Thank you, Chris. Senator Martin, I think you had your hand raised, sir.
Thank you, Chair. Hi, Chris.
Hello.
Just a quick question. These acknowledgements, are they going to be, will they be required to be visual, or is it just an electronically, they can do it through emailing? Can you maybe explain that to us a little bit?
Sure. So some of that gets fleshed out in regulations that our agency will publish under this bill. So the way RULOTA works is it sets the baseline for what the notarial software needs to do. And then it says the secretary is allowed to publish regulations further specifying what that software needs to do and the process by which software providers need to come to us first and get approval to offer that software to Connecticut notaries. So some of that is yet to be spelled out, but I have seen demos on this software, and so I'm sort of vaguely aware, although I will certainly defer to my colleague Mark Ladd from Property Records Industry because he has studied this issue in far more detail than I have. But yes, the act requires simultaneous video. You and I can see one another, right? And recorded, retained for 10 years, and the document be digital. That is, you and I are looking at each other and the document is also up on the screen. And so the notary goes through the notary's questions, and then then they instruct the person, okay, click this button, which is going to sign your name to the document. That happens, they click the button. Then the notary says, okay, I'm going to go ahead and notarize it now. And they apply their digital stamp, their notarization, the standard acknowledgement that Connecticut has. And then they hit a button that's usually like lock or save. And at that point, you have a PDF that's signed by both the notary and the signer, and it's encrypted. So is it impossible to hack? Probably not. Is it incredibly difficult to hack? Yes. And so that's how the bill treats this. You're actually executing a digital document that both people can see on the screen.
Got it. You sort of led right into my next question. The software, you said that there was videos. Have you guys got your hands on something that you could forward to us so that we could actually see it? Similar to the when we're all introduced or go to our orientation as state rep or state senators, we have to watch this video of how a bill is made, so to speak. It'd be interesting to see how this process would look.
Well, as someone who is into technology, I find it kind of cool, but in our role as the government licensing agency, and the secretary mentioned that Rulona is endorsed by our association, the National Association of Secretaries of State, and the guidelines that NAS underscores is to say that the secretary's role is to be technology neutral. So yes, we could point to examples of companies that are offering this throughout the country, and I don't want to name them because I'll forget someone, and then they'll say, you know, why did you name this company and not another one? But there are four or five major providers that do this. But that's to say, they still all have to go through the same process. They still have to, even though they've proven themselves in 30 other states, they're still going to have to prove to us that their software is able to meet the minimum qualifications of Rulona. And it's open to any other small software company. If they think they can make a piece of software that's compliant, they can do it too. So it's really intended to be technology neutral, and that we're not trying to pick winners and losers. We're trying to say, here are the standards. If you can prove to us that you meet the standards, we will approve your application and you will be allowed to market it to Connecticut notaries.
And that number, there's no number of software companies that we're going to limit this to. It'll be opened up to anybody in the country, actually, who has this type of product.
Any software provider that can prove to us that they meet the minimum qualifications would be approved. And then they would go on a list that our office provides that will say to Connecticut notaries, you're required to pick one of the providers on this list. You can't pick like Zoom actually doesn't comply. I think some of the providers use Zoom technology for the video conferencing, but because Zoom wouldn't meet some of the other qualifications of it. So this is very, specific software to this industry. And yes, there are I think 4 or 5 sort of major providers right now, but hold open the opportunity for innovation. If some Connecticut company wants to kind of innovate in this area and start competing in this area, they're perfectly eligible to, so long as they can tell us that their software meets the minimum qualifications.
Chris, thank you for answering my
You're
question.
welcome.
Appreciate it. Thank you, Madam Chair.
Thank you. So not to belabor this, but this is, a very important and intricate conversation. So Chris, we talked a little bit about fraud and so forth. And I'm sitting here looking at you on Zoom. How do I know somebody doesn't have a gun in your back? I'm going to be pretty dramatic here, say this.
So that's true. And we considered that. So we actually had a label for this that we called off-camera coercion. And we went back and forth on this. The issue is that there's not really any particular way to kind of avoid that. We think it's a particularly rare instance when that happens. So, and in that one hypothetical, you're probably right that in-person notarization is safer than remote notarization. You can't tell. My wife almost walked in on us, and I kind of shoot her away that she's going to be on TV or YouTube if she comes on. But you don't know that she's not standing right here and holding a gun to my head and making me testify like this. So you're right. We think when we considered this that the type of coercion that is more likely is sort of a wash between remote and in person. So that is the less aggressive kind of coercion, but the familial coercion. So we sometimes hear it in our office about notary complaints. You have 2 sisters debating over whether mom should sign a will or not, right? And so you have one sister claiming that sister A is extracting undue influence on mom, got her to put something in the will that sister B doesn't agree to. In those areas, it's kind of a jump ball between remote and in person, because how can you tell that mom's the person sitting in front of you? You're asking her, hey, this is your will. This is, do you understand what's in the will? I do. Do you understand, what a will is? I do. Are you doing this through voluntarily? Is anyone forcing you to do this? No, I'm doing this voluntarily. I want to get my affairs in order. Unless the daughter's sitting there right there saying, "Mom," it's very, that's the kind of coercion that we think is more likely. And we're not sure that there's anything you can really legislate here that is going to completely eliminate that risk.
Okay, and then just one last question. So we talk about the number of states, 30 other states, but who in New England, since we're, in the Northeast, a little bit more peculiar, you might want to say, as opposed to West or mid states or so forth?
I really need to, if it's okay to punt to Mark Glad on that one, I can look it up quickly. Well, with Zoom, I'm allowed to be on 2 devices, so I can look it up on the computer next to me. But I believe Massachusetts has some form of remote notary law, but doesn't have, I don't want to speak to this. I don't want to say something that's incorrect. I know Pennsylvania is considering it right now, not New England, but somewhat close. And New Jersey is also considering it right now. So I will have to defer to Mark, who's the expert, because he's on the Rulona state committee that is set up to encourage state legislatures to pass this law. So he's got his finger on the pulse of what states are doing what.
Okay, thanks very much, Chris. I see no other questions. And Mark, apologies that we've got people on deck waiting. Go ahead, sir.
So in terms of other New England states, I think Chris maybe flipped those. Massachusetts is considering a remote notary statute. Pennsylvania, though, is in place, has been actually for a while. But other than that, then you start to get into more Midwestern Ohio. Of course, Virginia has the oldest remote notary law in the country, dating back to 2012. So they've been at it for a long time by comparison to the rest of us. Kentucky is another state that has not as strong a unauthorized practice of law scenario as Connecticut does, but has a very, very strong history of requiring or strongly recommending attorneys be involved in real estate closings. So to that issue, that's another state that is doing remote online notary with a very, very strong unauthorized practice of law rule in place. So hope that's helpful.
Yes, thank you. So Mark, thanks for being with us. And I don't know if you have a statement or whatever, if you would like to respond to our conversation exchange so far, but you have the floor, sir.
Well, thank you, Madam Chairman. My role here on the working group and available to the committee would be that I am past president of the Property Records Industry Association. We're the national standard setting body that sets the standards for electronic recording that is used by the county clerks and recorders across the country. That's a volunteer thing that I do. In my day job, I work for ICE Mortgage Technology. We work in all 50 states in the mortgage business, and we work in all 49 states that allow electronic recording. And so I've been offering to the committee a broad set of national perspective as to what's going on in some of these other states. As Chris has noted, in addition to the 18 Rulona states, there are a dozen states that have adopted the Mortgage Bankers Association Model Act. It just happened to be ready before the Uniform Law Commissions Act was available. Very, very similar in provisions. So yes, there are about 30 states that currently have remote online notary laws in place. We don't see from our perspective, either with my day job or the Property Records Industry Association hat on, any reason to exempt real estate transactions from remote online notary. And there is precedent, like I said, in 30 other states. So if there are any questions that we can answer along the way as to what other states have seen, how other states have dealt with something, that's sort of the role that I've taken here. Obviously, as a member of the Uniform Law Commission's RULONA Adoption Committee, we urge adoption of a fairly uniform adoption of RULONA. And I know that you've got somebody else, you're one of your Connecticut Uniform Law Commissioners is on deck to testify. So I'll let her speak on behalf of the Uniform Law Commission. But if there's anything that I can answer for any of the committee members along the way, in practical terms, that's what I'm here for. Happy to be a resource.
I would just have one general question to you, sir, and that is Connecticut peculiar to any state with regard to adopting RULONA and remote notarization? I mean, we had heard previously that because of our, I don't know, legacy of village districts and other such entities, that we stand out and are different in terms of how we could adopt this technology.
Yeah, I mean, every state, one of the fun things about being in the United States of America is that we might as well be 50 different countries in some ways. So every state has its unique quirks and practices. And Connecticut isn't any different in that regard. There are some things that are unique, but as Chris pointed out, I think the working group worked through the Model Act, paragraph by paragraph, to address those specific issues. And I don't recall anything that the working group came across that was, so unique that it was a major stumbling block. Even in the area of real estate closings, again, all of these platforms that facilitate remote online notarization would have the ability for the attorney to be involved, to be present, to supervise and to conduct the closing. So I see this as an additional tool for the attorneys in Connecticut who are doing real estate closings to meet the needs of their clients, and not just in a pandemic. There are disability considerations. Americans with Disabilities Act, people who cannot travel. My 86-year-old mother used remote online notarization toward the end of her life when she didn't want to travel. People who have travel limitations, they don't have their own vehicles available. So there are other uses of this technology than just pandemic and millennials who like to have their noses in their devices at all times anyway. So I think that nothing so unique about Connecticut that there were major changes that needed to be made to RULONA, and I think you'll find that the adoption should be fairly straightforward.
Thank you, Mark. I'm looking to see if we've any hands raised. I see none. So thanks for being with us today. Kathy Makeover from the Connecticut State Library. Are you with us, Kathy? Madam Clerk, hi, Kathy. Are you muted?
There we go. Yes, it's
Okay.
Kathy Makeover. I'm with the State Library, which is the state agency that's responsible for government record management, both for the state agencies and the municipalities. My focus is municipal records management, and that includes the land recordings in the town clerk offices. So the State Library absolutely supports the adoption of this bill with the removal of 15J. And our main concerns are really consistency in land recording practices for Connecticut with all the other states in the country, and also consistency in land recording practices among our 169 towns. And RULONA, as we've originally drafted it without the 15J, will accomplish both of those goals. So without having that consistency, we are going to continue to see complaints coming in directly to the town offices, also to our state office. Examples would be people who cannot understand why they can record an electronic format document in one town in Connecticut, but not in the next town over, because there's a wide variety there between where you can and can't do that right now. Rulona would address that. And another example of complaints that we hear are when someone cannot understand why they can use remote online notarization services for property that they own in another state, but not in our state. So right now, as a couple of people have said already, there are 30 states with permanent legislation already on the books. So we're not talking here about the the temporary orders like we have in Connecticut, but permanent legislation, which all 30 states allow for remote online notarizations for real estate transactions. If these type of transactions are excluded from the Connecticut adoption, we are going to be out of step with all 30 states. And right now, as I understand it, there are at least 10 other states like we are right in the process this year of adopting similar legislation. As Mark pointed out, and the reason you're kind of hearing different numbers at times, like 18 with Rulona, there's the Rulona model, which includes remote online notarization for real estate. And then there's the MBA mortgage bankers and the title search. I forget, it's ALTA, I forget what it stands for, Mark could fill me in. But these models, as he said, developed kind of at the same time, but made a real effort to make sure they were consistent with each other. And both models have the intention of allowing for remote online notarization for real estate. So the states have either adopted one or the other, but that totals to 30 states that have already adopted it, allowing for that type of real estate transaction, and another 10 at least that are in process this year, including us. So very soon that will be 40 states. So if we go forward with this exclusion, it just creates a lot of confusion and problems that I don't think are really need to be there. It would be nice to have consistency. We do understand, I think, the concerns that some of the attorneys have been raising about the remote online notarizations in certain situations. We also believe that for some clients and in some situations, remote online notarizations are actually a good option. They're not appropriate in some, they are appropriate for others. But the really positive thing about Rulona is that it doesn't require attorneys to change their practices in any way. It's always up to their discretion, whether to go ahead with remote online notarizations or in-person electronic notarizations or old-fashioned paper version. All of those options are there in Rulona. So in my mind, and someone can correct me if I'm wrong, but if we pass this, if we adopt this legislation the way the committee drafted it without 15J, and every attorney in the state believes that real estate closings should not be done with remote notarization, they won't happen. But meanwhile, the state will still have the same law on the books as every other state, and it will just simplify things in so many ways. I feel like part of this may have just been some of the complaints or disagreements that we're hearing very last minute here, just before this, came to committee. It feels like some of it is just a communication problem, and that if people had the advantage of sitting in a room together the way we did over so many months and talking about these issues, getting feedback from experts, which Mark Ladd is definitely an expert in this area, some of these questions would be answered and they wouldn't be such huge concerns. But we really do support the adoption of Rulona as it was originally drafted, because it's going to create a foundation for consistency in land recording practices across the country, which is just crucial, and also across our 169 towns. It supports both efforts, and it will just really be a positive step. So I can answer any questions if anyone has.
Yes, thank you, Kathy. No, I get this issue about the consistency throughout the state of Connecticut. So on a municipal level, are we equipped? Are we equipped to go forward with something like this?
We're not only equipped, well, I may not be understanding your question, but as I understand it, we're fully equipped, and it will actually make things work so much better, because right now, I imagine Anna from the Town Clerk Association may speak to this as well, because it's sort of like her office and my office, even though they're different types of offices. She's the president of Town Clerk Association. We both are fielded these complaints, and some days we'll talk to each other. It's like, did you get all all these emails today? And me too, because people are coming in because they're coming to us because they don't understand the inconsistencies. There is e-recording in the state. We've had it since 2013, which means that an electronic format document, electronically signed, electronically notarized, can be submitted in towns that offer e-recording. And also, that only applies to submitters that have contracted with an e-recording vendor and have the ability to submit through e-recording. What Rulona does in part is it provides the option to print out an electronic document, have it certified as an authentic copy by a notary, and then submit it just like all the other paper recordings have been submitted for hundreds of years here. So we're not only equipped, it will actually make things work better within all the towns, is my opinion.
Where are the complaints coming from?
People that need to record documents on the land records, our own residents, people calling from out of state that can't figure out how they're going to do something because they're out of state. People that just don't, and I don't blame them in some ways. They don't understand why last month they recorded an electronic document in town A, and now they go to town B and they can't do it. And Rulona would solve that problem.
Do you have any idea, and maybe I should ask the town clerk representative, what percentage of towns are not equipped to accommodate e-recording?
Anna can speak to this as well. I don't know that we have the exact number in this moment in time, but my understanding is about 70 do offer it, and the other 199, whatever it is, do not. And there's a lot of issues there. It's not as simple as like, let's just tell them all they have to do it. We'd like to do that, but it's not as simple because the towns range in size and in resources, and a lot of them, they feel it will be very difficult for them to offer right at this point in time.
And it could be a municipal expense.
Mm-hmm. In some cases it could be, and again, Anna might speak to this even better than me. In some cases it's the expense for the software. In some cases it's managing the ACH transactions. A city with a big finance office can easily do that. A tiny town maybe can't.
Thank you. Thank you very much, Kathy. And I'm just checking. I don't see any hands raised. Thanks for being with us, and we're grateful for your input here. Bruce Adams, are you with us, Bruce?
I am, Senator. Yes, thank you.
Hello. Hi, Bruce.
Hi.
You've got the floor, sir.
Thank you. I've submitted written testimony, and I'll commend it to you to read. It's short, but I think in light of the conversation that's happened heretofore this morning, it's important to present the perspective of the real estate lenders in this. And notably, they're not concerned. Notably, even the Connecticut Bankers Association opposed Public Act 1988 in 2019, albeit on different grounds. For the people taking the largest financial risk in loaning out money for the purchase of a house, you don't see them coming forward today to inveigh against allowing for remote notarizations here. On the credit union side, it's important to remember too that credit unions act very much, as a financial cooperative in service to their members who are essentially owners of the financial institution. And they want to build by design as diverse, more equitable, and more inclusive environment. And to do that, they need to reach all of their consumers. I think if there's one thing that we've learned throughout this pandemic, immunocompromisation is a real thing that needs to be accommodated. So when we have members who, for one reason or another, are concerned and reluctant to engage in the financial services industry, what that means is they may end up underbanked, underprepared to engage in sophisticated financial transactions. But I think above and beyond all of this, what's really important is that the lenders themselves could still require an attorney to be intimately involved at whatever stage of that transaction they want that attorney to be. So nothing is precluding attorneys from requiring this kind of involvement. But here, for either the younger consumer who wants to do things remotely, or a member of the disability community with mobility challenges or immune issues, who needs a service like this, I think that the equities outweigh continuing to make a sort of a carve out here out of unspecified sort of threats of fraud. And I would say, some of you may remember me, Senator Martin, as the acting commissioner and general counsel of the Department of Banking. And I've been involved in real estate transactions from the financial institutions perspective now for many years. And there just isn't a great hue and cry over this in that community. And I think that that's really notable. And certainly as a lawyer that's done litigation, that's done transactions, that's been the top lawyer for our banking regulator, I know that as a lawyer, I don't receive any special training in assessing a person's mental state or whether there's duress or coercion. I'm taught legal principles and I'm taught to put the pieces together, but I'm not a psychologist. So I think that we need to fold that into our thinking when we think about allowing for a remote execution of documents that may very well have been involved. A lawyer may have been involved in advising as to the execution, but a notarial act is an executorial thing. It's not an advice situation. So I think that the unease in a certain community as to this bill may be slightly misplaced or overstated. But with that, I'm happy to answer or respond to any of your questions.
Thank you. Thank you very much, Mark. So I would, Bruce, I would just say, how would you respond on the risk benefit of adopting Rolona remote notarization in relation to the conversation we had a little earlier on the not necessarily impersonation, but coercion. The extreme example where somebody, off camera is coercing the person who is speaking. And the response was, well, that really could happen, but we think that that's really the exception in this instance. So what's the risk benefit here? Is it worth it? That one person who is in the room with someone who is coercing them?
So, and I think it's an excellent question, and I think that it deserves, following up on, given the fact that Representative Doucette's response to what his experience was identifying that stuff contained no data, no actual experiences in a real estate transaction. we don't really know, but I know either through my role as a regulator, through my role in private practice, or another involved, or certainly in my role representing Connecticut's credit unions, that let's take the last role, if my members were concerned about this, they would have me on the opposite side of this issue in the blink of an eye, because they're the ones that are putting hundreds of thousands of dollars on the line on a promise against a transaction that could get scuttled or sideways because somebody comes and cries foul. So rather than talk about sort of the policy behind the thing, you appropriately bring up risk, Senator. That's dollars are the best indicator of risk. And here the lenders want to have a service like this to provide customer service to their members. And I would add, in the credit union space, because credit unions are democratically controlled by the members themselves, their boards of directors are customers of the credit union, and they're a closed financial cooperative, they're much more risk sensitive because they can't go out and raise outside capital. So they're very, very careful with the deposits they receive, putting that money out on the street. And they are just simply not concerned with this bill at all.
Well, thanks for that answer. Then you could go on to say, but that is a business entity, a financial entity, as opposed to the individual whose one asset happens to be their house, which is obviously they're representative of maybe their entire life's work. So in that instance, there's the personal consumer issues. But thank you for your response on that. I don't see any other hands raised. If I'm missing something, holler out, Madam Clerk. And if not, thanks so much, Bruce. And I'd like to now invite Anna Posniak, who is representing the Town Clerks Association. Hi, Anna.
Hi, thank you, Madam Chairwoman. I am Anna Posniak, Windsor Town Clerk, and I'm here representing the Connecticut Town Clerks Association. And we are in support of HB 664 with the removal of section 15J. As mentioned, remote notarization has been in place since 2012. So this is not cutting edge technology. And I know we're the land of steady habits, but there is a point when we need to start looking to bring our technology in line with other states so that it makes it easier to do interstate commerce. As mentioned, also, there was the remote notarization group that we all were brought in from various sectors of the industries, and everyone had brought forth a particular niche of the marketplace. And I brought forth to the table my perspective as a town clerk, as a land recording agent, and also a practicing notary whose office does about anywhere from 10 to 20 notaries a day. With many, we are one of the few town halls that is open to the public with no appointment needed. So we've seen a large influx of Connecticut residents coming into our office to want to have notarizations done. So I can speak very well towards any questions regarding notaries if you have any. But our working group did spend many hours contemplating RLONA and aligning it with our state statutes. One of the things not mentioned today is that the federal government is looking at the Secure Act, which will, if passed, would require all notaries to perform remote notarizations, and we would then have to follow the federal law. But if we passed a remote notarization law in Connecticut, we would be grandfathered in, and our working group looked at all of the state statutes and made sure we were in line with those state statutes. And we were certain that all of the parties that were present, that their concerns were addressed. So I just, again, to repeat, but I think it's important to repeat, is that remote notarization is not a replacement, but an adjunct of traditional notary services. Attorneys, lenders, consumers are always given the choice in whether if they want to use remote notarization during a closing. Remote notarization is simply just another tool for attorneys in Connecticut or bankers in Connecticut to use. If they don't want to use it, they don't need to. In addition, notaries in Relona are not authorized to practice unauthorized practice of law. And since the pandemic, we have seen a demand from our residents for e-services. With town halls closed and all of that, residents are wanting more than ever to have e-services. And our residents, they know what they want, and they want to be certain that they can get that. If they can't get it from businesses or notaries in our state, they will go to other states. So we are driving business outside of our state. So we need to be cognizant of that. So we can't look at the short-term demand. Connecticut needs to look ahead at the consumer's demand for remote notarization. Additionally, town clerks and real estate attorneys will benefit from this bill, as town clerks now will have the ability to accept hard copy land recordings that have electronic signatures. So for the past decade or so, town clerks have been grappling with how to handle any land recording that comes in a hard copy that has an electronic signature, because that contradicts a current state statute on that requires all land documents to have original signatures. As the Connecticut, as president of the CTCA, I field calls from attorneys who are upset because a particular town clerk in a town will not accept the recording, and they want me to call that town clerk and tell them that they have to record that document. And, I get these from other bankers and town clerks, calling me, calling Kathy, asking us for guidance. And I'm not an attorney, but I try my best to assist them. But this bill will put into place measures that will allow town clerks to be able to record any land documents with electronic signatures. This will finally align our recording process with the 30 other states that already have adopted Relona legislation, so that there will be a more uniform intercommerce transactions for both the local banks and the national banks. And this will definitely make it be easier for businesses to do business in Connecticut. So please give serious consideration to removing Section 15J and passing the bill, because we must allow Connecticut businesses to remain competitive in our national and global economy. Thank you. I'll answer any questions you may have right now.
Okay, Anna, thanks an awful lot. Your testimony is very instructive here. So what happens in that situation where a town clerk is not accepting an e-signature, and the attorneys involved are, saying this needs to be accepted?
So if the town clerk refuses to record that document because Section 47-5 does allow us to reject that, then it requires the attorney to go back to the homeowner or the bank, and then they have to do the document again, acknowledge the document again. And it's time for the attorney and a waste of time for the resident as well, while they process that document a second time.
How often does that happen?
It seems to go in cycles. Kathy and I were commenting, it had been like a week or two where we hadn't heard from anybody. And it was on Monday and Tuesday, our, email and phone was just, going, constant questions about this. So it's on a pretty regular basis, especially when you're talking about banks that are national banks that, do business like all across the country. When the standards are not the same from state to state, they don't necessarily realize that there's a state statute that prohibits that. And so they submit it unknowingly.
Is it increased during this situation of the shutdown, the pandemic?
It absolutely has increased since the pandemic.
You talked about interstate commerce. So this is exactly what you're talking about, right? When we've got an out-of-state individual who's trying to close remotely here in Connecticut. Can you talk a little bit about that?
Sure. There's a couple scenarios. So I could have a Windsor resident who is a snowbird living in Florida, and then they finally decide to sell their home in Windsor. And so they still want to work with their attorney that they've utilized, throughout their whole life here in Windsor. But now what they need to do is one of two things will happen. The attorney will send them the whole entire closing package, and they'll use the notary services in Florida. And, in which case they could, if they wanted to, because Florida law allows for remote notarization, they could do that, or they could have an in-person notary assist them with that. Or the other thing that might happen is that the Connecticut attorney might have the couple fill out a power of attorney, allowing that attorney to complete the paperwork for them. So the attorney would have had phone conversations talking to them, similar like they would if they were on a remote notarization platform, and then they would complete the power of attorney, and then they would submit that to us. And then at the closing, the attorney would sign all of the documents on behalf of the residents. So as you can see, remote notarization would allow those residents that ability who are in Florida to actually be at the closing and to hear everything that's going on and have a good understanding of what's happening, and then to also sign those documents electronically.
So just comment about fraud. What's your take on that?
Well, there's nothing to preclude, fraud from happening at my counter as well. I will say that as a notary, we try to have conversations with the people who are coming to our counter. If somebody's coming in and having, a document notarized because they need something for school or something like that, we may not engage in much of a conversation. But if someone's coming in, like, for instance, if it's an elderly person and they need to sign off on their husband wants to take money out of their pension. So then the other spouse needs to sign a spousal consent form. We will engage in conversation to make sure that we're seeing if there's any coercion or anything like that. And that's something you kind of look for signs and cues, like if someone's looking towards someone, to see if they're looking to, be coerced or something like that. A good example that I had in Windsor was that I had a woman come to my counter. She was 48 years old. I would have no reason to believe that the woman had, dementia. And I noticed that she kept looking at her son and her husband back and forth as she's about to sign the spousal consent form for her husband's pension, which I caught onto that cue, and I said to her, is there something going on here? And then that's when the son divulged that his mother had dementia. So at which point then I stopped the transaction. I said, I need to be able to talk to your mother. And I asked her if what year it was, who the president was. And these were all these normal questions that you and I could answer. And she was not able to answer that question. So I stopped the transaction and I did not notarize the document. And that's something also anyone who is a remote notary can do. They can cease the transaction at any
Senator Hartley, it's Will. How are you?
Yeah, sorry for that interruption. So yeah, that's those kinds of situations is what we're trying to anticipate. So Anna, what percent of notarizations would you say are other than real estate and land recordings, deeds, wills?
In Connecticut, it's a really small amount that are real estate. Most residents, utilize the services of an attorney. What we see if we are dealing with any kind of notarization, it's for the property that's in New York State, the vacation property, or in another state that they're trying to sell, and they need us to help them, signing the deed, to notarize the deed. And the other thing is that we will assist with quick claim deeds. When anyone comes into my office that says, I want to add my husband to my deed, the first thing that any one of my staff members will do is direct them to the services of an attorney, because the couple may unintentionally complete the legal document incorrectly. And then, what they intended to do was to add the husband, but instead the wife might have taken her name off completely. So we always encourage them to go to an attorney. But, not everyone can afford to do that when they're just simply wanting to do a quitclaim deed to just add their spouse on. So they will complete their own quitclaim deed and they will file that with us. So in some cases, we will assist them with the notarization process. I will not assist them with a deed that's for property in Windsor, but if it's a property in Hartford or Bloomfield or something like that, we would notarize that document for them.
Thank you. And thanks for all of your explanation here and patience waiting for us. I see no other questions, Anna, and thank you also for your leadership with the statewide association. My own town clerk, Chicky Spinella, did this some years ago, and I appreciate the task that it involves. So thanks and kudos to you for that. I see no other questions, so I would like to now invite Carol Christensen, who is stepping in for Tammy Fellenstein for the Connecticut Realtors, who is also part of this working group. Are you with us, Carol? She was going to use, Madam Clerk, she was going to use Tammy's link. Can you tell? Is she on deck? Ginger? Okay. Does not appear to be. Yeah. Hello. Hi, Wendy.
Hello.
I'm sorry. You backing up?
Let Tammy in.
Yes. Oh, hey, Tammy. There you are. Okay. Thank you very much. So you're back with us. Much appreciated. You have the floor, madam.
Thank you, Senator Hartley. My name is Carol Christensen.
Oh, you're
yes,
Carol.
Carol. Yes, I'm using Tammy's link. Tammy was unable to come today for a medical reason. So I am Carol Christensen, and I am the president of the Connecticut Association of Realtors. Thank you for letting me speak today. CTR represents over 17,800 realtors who practice real estate in every municipality in the state. The removal of real estate transactions from the remote notary process ignores the efficiencies, cost savings, and security that online notaries can provide. Our clients are all over the country and they're all over the world. And there's no reason why these clients should be required to travel for a process that's been done effectively in other states for almost a decade. An electronic recording of a transaction is safer, more reliable, and more detailed than meeting in a parking lot or at someone's desk. And permitting the remote notary does not require that every law firm has to adopt it. Many consumers may still only feel comfortable meeting in person, while others would find value in being able to perform their financial activities digitally. The pandemic showed value in removing unnecessary barriers to commerce when electronic options are available. CT applauds the work of the Secretary of State and all of our partners in this endeavor. CTR believes that remote notarization is a tool which can be used to modernize the closing procedure and should be available to consumers if they wish to take advantage of it. In conclusion, CTR strongly requests that you reject Section 15J of HB 6604. Thank you for your time and attention to this matter.
Thank you, Carol, for being with us, and thank you also for your participation on this working group. So could you comment on the instance or the percentage of interstate real estate transactions that the association might have some knowledge about?
I personally wouldn't actually know any percentages. I can just say that I work in Southeastern Connecticut, and even prior to the pandemic, I work a lot with the military. And this happens quite often that people are purchasing properties when they're not actually in state during the process.
And Carol, what about, the consumer safeguards here? What about the instances of coercion? We heard testimony to say that, appears to be the exception, not the rule. It is not the typical thing that happens. So what's the risk for the benefit that we would receive in allowing the e-notarization?
I'm not really sure how you want me, what your question is. Can you phrase it a different way?
Yeah, long story short, I'm concerned about consumer protection and the incidences of fraud. So we've heard testimony which said you're never going to totally have safeguards, guardrails against fraud, but it's worth adopting this technology for the overall benefit of the industry and of consumers. Fraud, tell me about, your assessment of that particular situation in this conversation.
Well, I would guess whether it's done online or whether it's done in person, there always could be some sort of fraud. I mean, I know we've seen it in the past. We've seen the wire fraud. And as soon as we find out how people are doing that, there's always going to be people out there that are trying to buck the system and find a way to get around these things. But I know as soon as we learn about them, we try to put those safeguards in place. I would agree that, an in-person closing, there could be something that's coercion going on that's maybe not in the room, but something that's been, said to somebody prior to going and signing something in person. So I don't think we can always 100% be sure that something like that isn't going to happen. But I think as we use this, if we do use it, that we would find that as we're finding issues come up, as your concerns are, that we would try to put additional safeguards in place for that not to happen.
Carol, thanks. I'm going to defer to my colleague, Senator Martin.
Thank you, Madam Chair. Hi, Carol. Thank you for testifying. You perked my ears here a little bit where you wanted us to reject Section 15J. I'd like you to speak to that a bit, and also maybe Chris, could you follow up and explain why, or respond to her response, I guess, or why that is part of this document. Thank you. Go ahead, Carol.
Well, that's, I think it's lines 338 through 341, where they're saying that this bill excludes real estate closings. And we're asking, we would like it to include real estate closings. So we'd like that to be removed from that section to be removed from the bill.
Senator, you wanted me to jump in?
Yeah, I'd like to. Why was that? Why would you exclude the real estate transaction in this?
We didn't. So if the question is what is it, it's in 15J, it appears to try to carve out an exclusion for real estate closings, wills, and codicils from the ability to do remote online notarization with respect to those transactions. That's the what. That was not in our draft that we submitted to the committee chair. So our testimony is we want that removed from the bill before this bill is JFS'd out of committee.
Okay, great. Thank you. Thank you, Carol. Thank you, Madam Chair.
Thank you, Senator Martin. And let's just see. I see no other hands raised. So Carol, thanks for hanging in there with us. So appreciate.
Thank you.
I'd like to now move on to another subject, colleagues, and this is a very important one to this committee, that's brownfields. And so we have on deck Anna Catino, who is on the State Brownfields Working Group, and also her co-chair, Gary O'Connor. Are you folks online on deck here? Hello, Gary, and let's see, do I see
Senator,
Anna?
how are you?
I'm good, how you doing?
And
she
I'm
got
not sure
tired.
if Anna's on. She was intended to be on, and I don't know if she had to leave for a mediation. So I told her I would be happy to take the load and speak on behalf of the entire Brownfields Working Group and her. So Senator Hartley, Representative Simmons and the rest of the distinguished members of the Commerce Committee. Thank you for allowing me to testify on behalf of Raise Bill 1038. I'd also like to thank you for your cooperation over the last 14 years in advancing the Brownfields initiative of the state. It's because of your support that Connecticut has one of the strongest brownfields.
Excuse me, someone is not muted. Excuse me, Gary.
Sure.
So folks, please mute your audios. Okay, hopefully we've got them all muted now. Thanks, Gary. Yeah.
Okay. Well, because of your support, Connecticut has one of the strongest brownfields programs in the country, and we've included in our testimony a number of those programs that you have enacted, and just to highlight a couple of the establishment of the Office of Brownfields Remediation and Development, the creation of grant and loan programs that are vital to the remediation of our communities, and new and very novel liability relief programs that are really have been copied by many other states because of their comprehensiveness and the creativity of those bills. So again, thank you for your support. Raise Bill 1038 is intended to further advance these brownfield initiatives. And it's the first two sections, there's three sections of the bill. The first two sections are for the most part, technical revisions of two brownfield programs that we already have and their statutes. And that's the Abandoned Brownfield Cleanup Program, or the ABC program as we call it, and the Brownfield Remediation and Revitalization Program, which we call the BRRP. What we have done is to clarify that liability relief granted on those programs or under those programs is dependent upon remaining in compliance with the terms and conditions of the programs. It seems pretty obvious, but it wasn't in the existing statute. So we agreed with DEEP that was something that certainly seemed appropriate. The other, one of the other main changes is that Section 1 and 2 will now allow short-term leases to be eligible under both the ABC and Brownfield programs. And this would be in the case where an applicant wanted to acquire the property under a lease option to purchase. Previously, and under the current statutes, anyone who would try to acquire property from an owner who may have been responsible for pollution on the property, that applicant under a lease option would be ineligible for the ABC or BRRP programs because the state considered any lease to be a contractual affiliation between the applicant and the owner that may have caused pollution. So in negotiations with DEEP and DECD, we agreed to carve out that prohibition and allow short-term leases, people that ultimately acquire property after having a short-term lease of 5 or less years to be eligible, because that's an important universe of potential buyers of these properties who are willing to remediate them. Oftentimes for financial and other reasons, they want to lease it for a few years before they actually close on it. So that's what we consider, although it seems like it's in the weeds, it opens up, as I said, a universe of potential buyers that will remediate these abandoned properties. The other changes in Section 1, we've also closed a loophole in the ABC program, and that under the statute as it exists now, there's no time requirement for an applicant who has been admitted into the ABC program to begin the investigation and remediation process. So, you know, and through our working group sessions with DEEP and DECD, we agreed that there should be a time limit, and that would be 6 months of the applicant taking title to the property. We thought that was fair and reasonable. And then finally, we added in section 1, currently there is no time limitation on when the commissioner of DEEP has to audit a verification. And let me just step back and tell you why that's important. Under the program, you know, the applicant will hire a licensed environmental professional to oversee the investigation and remediation of the property. And once the cleanup is done, the owner will have that licensed environmental professional, or as we call them, LEP, file a verification with DEEP. And in reality, until that verification has been successfully through audit, or the commissioner issues a no audit letter, that property really is not financeable, and it's really not marketable until that's done. And unfortunately, under the existing ABC statute, there was no time limitation on when the commissioner had to do this audit. So what we did is we revised the language to make it consistent with the audit periods in both the Transfer Act and the BRRP statute. So now the commissioner has to conduct the audit within 6 months of receipt of the final verification. You know, we think this is a good change. We've worked through these revisions with DECD and DEEP to make it consistent with the other programs. And I think it will provide more certainty under the ABC program. So those are the changes to section 1 and section 2. The one thing I will point out is we made a few additional revisions to the statute, and I talked to both Nicks about whether or not you have that yet, and they said no. The one major change that I'll just point out that we've recommended is the elimination of the last subsection in both section 1 and section 2, and that has to deal with, that's a provision that talks about how the DEEP can enforce the both the ABC terms and the BRP terms through the AG's office. In consultation with DEEP, you know, we agreed that that language was not necessary because in these statutes now are, you know, are provisions that say that the benefits derived from the statutes are completely conditioned upon compliance with the terms of the program that the applicant is in. So it's kind of self-correcting. If you don't do what you're supposed to do, you don't get the benefits. And so that language was unnecessary, and you know, we've requested that those last two subsections, last subsection in each of the two sections, section 1 and 2, be taken out. The final section that we have is section 3, which is a Brownfield Working Group's recommendation on a Brownfield tax credit. We've brought this before your committee, I think a couple times in the past, you know, although I believe it's made it out of your committee, it was never passed, and quite frankly, you know, we really think that this is an important tool in our brownfield redevelopment toolbox. It's something that many other states have, including our major neighbors, New York and Massachusetts. And what we've done is we've gone back and looked at their statutes and those of other states throughout the country, and we've taken what we thought were the best parts of those statutes and incorporated them into this one. And what, you know, the biggest problem with some of these statutes is that they provided no fiscal certainty to the state. You know, there was no caps on projects, and there was no aggregate cap on how much credit would be allocated in any particular year. So what we've done is we've actually addressed both those issues, and we've limited the credit to I believe 50, let me just look here, the lesser of 25% of qualified expenditures or $2 million for any project. We've limited the eligible expenses to just remediation. A lot of other states included not only the actual remediation, but the redevelopment itself, the new project that was built. We didn't think that was necessary. And we've also put a total annual cap on this of $10 million. You know, it's not a lot, but you know, we've always ascribed to the theory that let's crawl before we walk, and let's see how this program works. And we felt that $10 million possible exposure on the part of the state was really insignificant in the total scheme of things. So that in any one year, you know, the DECD commissioner who will review these applications on a competitive basis, you know, will consider when the project is going to be completed, when that project will be eligible for a tax credit, and take that into consideration, understanding the cap that will be in place annually, which is the $10 million cap. These tax credits are like many of the other tax credit programs we have, in that they're transferable. They can be assigned, and oftentimes large C corporations find the tax credits attractive and will pay a certain percentage on the dollar for them from the developer or business owner that's remediating a site. And you know, so we've provided that flexibility, because generally the actual developer of the site, and you know, in many of the first few years, probably a single purpose entity that won't have any income anyway. So the goal here is to create an incentive where at some point after the remediation is completed, the developer or business owner can monetize the tax credit and use this as another inducement to remediate and redevelop a brownfield site, which has, you know, as you know, all its built-in challenges. So that's kind of a summary of the tax credit legislation, and as well as the technical changes to the ABC and BRRP programs. If you have any questions, I'll be happy to try to answer them.
Thanks very much, Gary. And I also want to recognize your longtime expertise with the Brownfields program, and also convening and working yourself and Ann co-chairing the Brownfields Working Group, because to your point, this program has been perfected to be clearly a national model. And you know, you and Ann and that working group really have been the architect of this. So that is such a distinction for us here in the state, and we're ever grateful. And I just wanted to point that out today. So with regard to this LCO, we've got 4873 in front of us. Yeah, so on the time limits. So this was something we carved out the Brownfields program when we were talking about the Transfer Act, and when we put all of those new time limits in on the audits, verifications, and so forth. So now we're bringing this program in sync also.
Yes.
Yeah.
Yeah. This was one of the first liability programs, liability relief programs that was drafted. And actually, I think the original statute was before my time. And, you know, as these programs evolved, you know, you realize there were things that were important to make them work successfully. And, you know, and we've revised them as we've gone along. And so this is just one of those elements that's really important to make it a more successful program.
Yeah, no, I absolutely agree. And I think it's important to to articulate those timeframes, because that helps everybody in terms of scheduling, and then it provides that certainty on the other end for the developers of the project. So it has an exponential benefit. And then, Gary, you talked about some superfluous language in section 1 and section 2. Do you have the bill in front of you? Can you just identify those lines for us?
It's let me just look for it here. Hold on. Let me just pull it out. The first would be lines 193 through 205. That it's a subsection beginning with the Commissioner of Energy and Environmental Protection may issue a compliance order to any person whose application was accepted, you know, or they failed to comply. That was the original language that we had come up with the ECD, and then that's and deep. But when we thought about it further, the better way is just you know, to insist that the benefits derived from the program are conditioned on you know, the fulfillment of in compliance with the terms of each program. So so this language became superfluous. So that was in and that was for section 1. I gave you those lines, and then for section 2, I believe. Hold on, if I can find it. It's lines did I say 803 through 818.
Okay. Okay. All right. That's helpful. And then lastly, so we've got a cap of $10 million we're talking about for this tax credit. And yes, we have promoted this at least one other time. I'm not sure if it was more than that, but do you anticipate that there's pent up potential and we would reach that cap?
Well, let me just say this, that this won't impact this fiscal year or next fiscal year, because the tax credit doesn't become available until you know, the projects are entered into the program and the remediation is done. Yeah, I mean, we're hopeful that that there will be demand for it. I mean, you know, it's like any of the programs we have. I mean, the first few years, it's an education process, you know, and until people find out about them, you know, they're not utilized as much. But once they do, then, you know, you'll see more and more applicants. And, you know, and this is, again, it's just another incentive for folks to actually go out and remediate the sites. And the good thing about this is the applications are filed twice a year, and it's on a competitive basis, and the commissioner of DECD makes the determination, based on certain criteria that are in the statute. The nature of the project, the public health interest involved, is it in a distressed community, things like that.
Yeah. And the point is that, these are on the back end, so we get the benefit of the remediated project and the economic spin-offs from all of that. So in terms of trying to assess, what a revenue loss would be, you could argue that
Right.
there would be no project or a revenue. So thanks, Gary. Yeah, Co-Chair Simmons, I think you have your hand raised.
Thank you, Madam Chair, and thank you so much, Gary, for your testimony today, and for all of your and Ann's work, in our state for many years to help clean up brownfields and to revitalize our communities and protect our environment. I wanted to ask about the potential for job creation through this tax credit. And I think right now, when so many people are unemployed and looking to get back to work, I'm wondering if you could elaborate on, the potential jobs we could see by enacting this tax credit in our communities.
Well, I guess what the best I can do is analogize. I mean, the DECD is provided. I know you folks with reports on the leverage factor on grants and loans that are made, and it's been going up every year. And I know that at one point I read that for every grant or loan dollar that the state makes, there are 11 or more dollars of other funds that are involved in one of these brownfield projects, and a lot of that money it goes to there's a whole contractors who do the remediation. There's a whole industry that's been created to oversee and remediate properties. So I see that in the short term, the tax credit programs creating this type of short-term construction and remediation jobs, and then once the property is remediated, the construction jobs, and obviously the end goal of any developer or company that comes in and actually does this is to create a project. I'm involved in any number of projects, whether, I'm involved in one now that is going to remediate a huge brownfield site, recondition the buildings, and the redeveloper has manufacturing end users. So it goes from that, to the developers that have commercial uses for the properties, or mixed uses, housing and commercial. So it does create a temporary remediation and construction jobs, and the projects themselves, and that depends on each project, creates long-term jobs.
Absolutely. Thanks, Gary, for that answer. And then another question, and apologies if I missed this, but how many brownfields do we have currently in Connecticut right now? Or put another way, how many kind of contaminated properties that haven't been cleaned up do we have left right now in Connecticut?
That's a good question. And I don't know if anybody has an absolute handle on it, but I can tell you this: there are brownfields in every municipality in the state. It's not just a large, urban issue. It's the one factory town where the factory now has been abandoned. That may have more of a significance on that municipality than, a half dozen brownfields in a larger community. But I know that there are at least 1,200 brownfields that have been identified, and I dare say that there are even more than that.
Got it. Thanks for that. That's helpful to know. So still, we've made so much progress, but still, significant work to do. And I think this tax credit will certainly help in the effort to clean those up. And just, final thought in terms of, aligning with, federal, state, and local partners on this. I think it's such an opportune moment right now to be passing this with the historic investments from, the federal administration right now on environmental cleanup and, their commitment to supporting brownfield remediations, to supporting environmental justice, and, in the next potential stimulus infrastructure package that will support clean energy jobs. I think this aligns really well with what the federal government's doing, and just wanted to get your perspective on that. And if, you've had conversations with the EPA or any federal partners on this.
Representative, that's great insight. That is exactly why we resurrected it. We think that between the Biden administration's emphasis on the environment and cleanup of sites and their investment in infrastructure that's going to take place, that these all complement what we're proposing, and will, I think, create more interest in trying to get many of these brownfields that to date have been financially impalatable or infeasible to redevelop. Now, with these kind of programs on the state and federal level, I think it's even more possible and quite doable.
Definitely, I agree. So thank you again for your work and leadership on this, and we look forward to continuing to partner with you.
Thank you.
Thanks, Co-Chair Simmons. And Senator Martin?
Thank you, Madam Chair. Hi, Gary. Gary,
how are you?
Well, thank you. Just to clarify, so in the tax credit, the aggregate amount is you're asking for $10 million?
Yes, in any one year, the most, and that may not be achieved for a number of years, depending how fast the program would take off. But we felt it was important to put an absolute cap so that the state had some certainty what the total investment might possibly be in any one year, and that's 10 million.
So would that ask be ongoing then? So it'd be 10 million this year, 10 the following year, and thereafter?
Correct.
And any one applicant would be no more than $2 million. Is that correct?
Right, or 25% of the, I believe, of the eligible costs, which, I mean, there are a number of projects where the remediation may be only $1 million or less, but it's, but that extra tax credit money would be significant in inducing the developer to do the project. I mean, if it's a giant project, their eligible costs, even at the percentage limit, would be way over $2 million. But we felt that it wasn't appropriate to allow any one or two projects to take the lion's share of the tax credit allocation in 1 year.
I agree with that. Gary, going to follow up with Representative Simmons asked about the quantity or the number of brownfields. Is there a list that is out there? And you almost said, I think I heard you say that there are still sites unknown.
Yeah, there are sites that are unknown. I mean, it's the process it has been, to, I guess, to aggregate, the state has aggregated information that's been provided to them on sites that are out there. And, the number that has been discussed at our meetings is 1,200. But as I said, I don't think that really identifies all known, all brownfields that are out there in the state.
Sure, I can understand that. So roughly the number currently is 1,200,
Right.
and with more, anticipating more.
Yes.
I did have one other question. Do you currently have any other programs that provide incentives to developers? So you're asking for 10 million here. Are there any other programs that are tied to brownfield for developers?
And there are. There's a grant program and a loan program. The grant program goes directly to municipalities, and that, I think, historically, that program was funded, in the early years with some significant money, and then it's gone from $10 to $20 million annually. And that's for both the grants and the loans. The grant program is for municipalities only. And, the municipality can partner with the developer and secure a grant and use the funds to help remediate a site that it may have control over, and ultimately it will transfer to a developer. There is a loan program where developers can get low interest loans. And I know that in this round, there were a number of developers that applied, but there was certainly a lot more available funding for these loans. I don't think the loans, for obvious reasons, are not as attractive, and so that most of the money that's earmarked to these two programs goes out under the grant program.
So adding the tax credit would give you another tool, so to speak, to provide with the further develop these sites. Okay. And are you finding that the banks are getting involved as part of that stack? Because if you look at the municipality contributing a grant with a developer, and now then maybe they get a loan along with that. Are the banks participating in any of this?
The banks are participating in kind of the back end. But the way a lot of these projects work is, a municipality may have an inventory of brownfield sites. It may control some of them either directly or through a land bank, and they will get a grant to kind of investigate and identify the contamination, because, the first thing the developer wants to know is, what's my exposure? So it's important to really investigate the site and know what the cost to remediate is, or whether there's any migration off-site that could potentially be costly. So the municipality will investigate. It will probably use some grant funds to eliminate what I call hotspots, stuff that really can't be there. And then, the developer often uses the project itself to isolate soils. So whether it's underneath buildings, these are soils that you want to prevent from having direct exposure to people, but are not migrating, are not infiltrating the groundwater. So, whether it's the parking area is maintained as a cap, or the building itself is used to isolate soils. So in that sense, that's part of the remedial tool. And that part of the project, you know, will be funded oftentimes by traditional lenders, you know, and they become more educated on how this whole process works and involved. You know, for instance, I'm involved in a project now in Torrington where a affordable housing complex will go up. And in that project, you know, there was an EPA revolving loan grant. There was money from the state brownfields fund to the city of Torrington. And all that was used to do exactly what I talked about, eliminate the hot spots, investigate. And now the developer is putting up a two-wing structure, and that will isolate soils. In addition, parking areas will be used to isolate soils, and you know, a land use restriction will be put on the property, which requires the long-term maintenance of those caps and no disturbance language. You can't disturb those soils. And in that construction project, there are several private banks involved, putting up, you know, significant sums of money. I mean, so I think what the state and the federal money is done is to help level the playing field. And so now, you know, the bank come in and say, okay, we're, you know, the field is almost level. Those remediation costs or investigations are being taken care of from other sources. It makes the site now marketable, and we can come in and lend on the construction.
Thank you, Gary. Gary, just one more question regarding going back to the 20 million that we currently provide annually. Are those funds exhausted every year?
Yes.
Pretty much.
Yep.
Okay. All right. All right.
And some years it's a little less, and we have applications in the queue. Yeah.
You do great. All right. Good to hear. Thank you, Gary, for your answering my questions. Thank you, Madam Chair.
Yes, thank you, Senator Martin. And to that point, in this capital budget, Gary, I think we've got 10 in 10 for the brownfield remediation program. Is that what I'm recalling?
Actually, I've heard it's 20 and 20.
Oh, okay. So I have to tell you, I'm in the
Maybe you know
approach.
more than I do.
No. I
I'm
like
hopeful.
that. I like that better. Yeah, because in the past, this committee has put out 2020.
Yeah.
So yeah, and to your point, it has all been used, which talks about, quite frankly, you know, creating those urban greenfields, because that's what our greenfields are, urban centers. That's our open space. So, and it's all about the tax base and the multipliers. So this program, I mean, it's no secret why this program is showcased every year nationally in the discussion of brownfields. So we are looking forward to continuing to support your initiatives, and thank you for your testimony today, and our best also to your co-chair who could not be with us. So I see no other.
Senator,
yeah.
Just one other point. I know that there was some testimony filed by Michael Tran on behalf of the solar industry, and that was to consider some incentives or a pilot program to encourage the location of solar farms on some of these brownfield sites. We're certainly where it makes sense and it's the best use of that brownfield site. We're certainly, supportive of that. That was the only other thing I wanted to mention.
Well, thanks for that comment. And in fact, Michael is next up on deck. So that's a perfect segue. Yeah. Thank you.
All right. Thank you, Senator.
Okay. Take care. Be well. And so, yes, Michael Tran is here from Solar Connecticut. You have the floor, sir.
Thank you, Senator. Members of the committee, my name is Mike Trahan with Solar Connecticut, which is the state's solar industry business group. Our members are home solar installers, but for the purpose of this bill, our members are also commercial developers, companies that put solar systems on commercial rooftops and also develop ground mount systems, football field size projects and larger, which you may have seen starting to sprout up around the state. I heard it mentioned earlier that the current brownfields program has gained prominence across the country as a national leader. We have a way, I think, to make that program even better and create several hundred jobs at the same time. Back in 2017, when legislation was passed to restrict certain pieces of forest and farmland for commercial solar development, there was a section in that bill that called for the creation of a pilot to put solar on brownfields and a follow-up report to detail the progress of that pilot and to decide whether or not they should go forward or not. We're not aware of that report being filed, but our interest is still very much in putting solar on brownfield sites across the state. We have a number of issues that we brought up. We submitted testimony with language that we wanted to suggest to the committee. So really what we're looking for is to restart that process that started in 2017, only this time include rules for safety for workers and for the department, DECD and DEEP. And if the Brownfields Working Group wanted to participate, that'd be great too. Our stakeholders would love to participate in the process also about building good safety practices and to determine ways to understand actual ownership of some of these sites, which I understand can prove difficult, and a way to deal perhaps with back taxes on some of those sites. We listed a number of those criteria that a report by DECD and DEEP could enlighten us all. As I said, there are a number of developers, solar developers, that would like to install systems on brownfields. Some of those systems could produce power through virtual net metering, whereby credits could be transferred to municipalities to help them lower their electric bills. It's a win-win. So that is our short request, basically report to restart the process that started in 2017. That's my testimony, Senator. Happy to answer a question if I can.
Well, thank you for being with us today. So you're saying that there was a pilot program that was launched in 2017 as a result of this report that was a DEEP report or a DEEP and DECD report?
Actually, in Public Act 17-218, there was a section that called for DEEP to conduct the pilot program and for a follow-up report to be filed with, I believe it was the Energy Committee, the Environment Committee, to detail how the pilot went and make recommendations on whether to continue it or expand it. We're not aware of that report being completed, but we're simply asking that we'd like to work with both DEEP and DECD to kickstart that process once again, to create either, I think we're past the pilot program, but I think we're ready to develop. We're just looking for rules and regulations that other states may have already. I think we mentioned in the language that we suggest that state agencies would be encouraged to work with state jurisdictions that are already doing this, already putting solar on brownfield sites that aren't likely remediation candidates.
Okay, so then did the pilot program ever happen?
I understand that it may have started, but that there may have been some problems at some point. That's what I gleaned from some comments from some staff. Although there was supposed to be, I believe, up to 2 or 3 megawatts worth of pilot program to be completed. DEEP was to recruit developers for that work. I've spoken to people at DEEP who it's not clear to us that was completed. I know for sure. I don't know for sure. I've asked for this report, and I have not been able to find it. So it's our understanding that it may not have been completed, and we're simply asking to start over.
Okay, got it, Michael. Thank you. And it certainly is a topical subject right now. Energy efficiencies, utilizing to every degree brownfield sites, and developing alternative energy sources. So that checks really all the boxes, sir.
Right. One more check would be providing revenue stream for municipalities on those brownfields.
Yeah. Representative Simmons has a question, sir.
Thank you, Madam Chair, and thank you, Michael, for your testimony today and for all you do to promote solar across Connecticut. And I'm really interested in this and wanted to see if you could elaborate on any municipalities you're currently working with, and if you have estimates on like you said, the cost savings that this would provide for municipalities and towns.
Sure. So I've heard from several developers who've approached municipalities trying to find out who the actual owner is of some of these properties. In some cases, it's a business that went defunct 30 years ago, and there's back taxes on the property, and the property is kind of a hot potato right now, and it pretty much stops there in terms of making use of that property, either in terms of creating a revenue stream, a property tax revenue stream for that municipality, or if the power that was generated on that site was then uploaded to the grid, and then the credits could be virtually transferred to the municipality and help them reduce their energy bill. It's a common practice that's used right now, although the program is capped. We're trying to work with the Energy Committee to lift that cap because a number of municipalities want these credits and can't get them because of the cap on it. But there are, it's a good way for municipalities to deal with properties that are sitting idle and create either revenue stream or reduce their energy bill at the same time. But right now, there are some barriers to doing this. Finding out through the local records who actually owns the property. Can it be brought into control of the developer? What sort of safety precautions need to be put in place to see that everyone who works on the site their safety is guaranteed, and a number of other issues that we speak to in the language. But it seemed as though 4 years ago in 2017 that there was an interest in doing this. I understand that the staff at DEEP are still interested in doing this, but there are just no rules in place. There are rules in place right now to remediate sites, to clean them, but there are no rules in place right now to address the development of sites that are currently contaminated.
Got it. That's really helpful. Thanks for that insight. And yeah, it seems like this is really important opportunity to be able to use already contaminated land for solar projects, and to kind of lessen the pressure to have to find other open spaces for that, and to provide these cost savings for municipalities as well as clean energy and the credits you mentioned. It seems like a win-win. So in addition, I'm sorry, go ahead. Were you gonna?
Yeah, well, I was going to say that there are some locations that won't be candidates for this. I mean, I think there's certainly good, high value properties in municipalities that are in good locations that once remediated would probably become an office building or something that would return greater value to the owner. But there are also locations that are in remote locations that in all likelihood will not be remediated, or no one's expressed an interest in cleaning up those sites. Those would be the sites that developers would be looking at first.
Got it. Thanks for that clarification. And in addition, I know you mentioned working to lift the cap for municipalities on credits. Are there any other suggestions you would have for us to be able to help enhance this program in Connecticut?
Well, I think we talked about. I think job one is to determine which other jurisdictions are doing it right. I've heard secondhand. New Jersey has a program. New York has a program. We haven't pinned those programs down, but I think job one is simply to find out how the process is working in those states, and then apply that process here. Outside of that, I can't think of anything. On top, I know that there is as good as the virtual net metering program sounds, the program is capped. There's a number of municipalities who are trying to get in and get those credits so they can reduce their energy bill. But the program remains capped at a very low number, and it makes it very difficult. So I would encourage leadership to perhaps consider at some point in time, maybe not this year, perhaps next year, a joint meeting between energy and commerce. I mean, there's so many issues, not just this one, but there's so many jobs related issues that can come from clean energy development that other states have deployed, but we don't have here because of the caps on the growth of solar programming. There are jobs, there are clean energy jobs to be had, and that maybe perhaps a closer association between commerce and energy might be able to produce.
Thank you for that answer. And I think that's an excellent suggestion and something we could definitely take up in the future. And I think especially too with federal funding that's going to be coming down to states for clean energy jobs, I think this is an opportune moment to be looking at this. So thank you for your testimony. Thank you, Madam Chair.
Thank you, Co-Chair Simmons and Senator Martin.
Thank you, Madam Chair. Hi, Michael. Hey, Michael,
Yes,
you mentioned a couple of times regarding safety, rules for the employee safety, and then went on to address, the rules for developing the site. Is there anything else that you're concerned about regarding safety?
Well, safety is number one, Senator. I know that there are in some places they call for 6 inches of fill to be dropped down. Or some sort of other permanent cap on the location. I know that when you permeate the property, that causes some issues, which would have to happen with a ground mounted system. You're going to fix it to the ground in some way. So there has to be some barrier between the system and the ground. But I think if we could overcome that hurdle, that would probably be the biggest one that I can think of at this point. But I mean, there are other fundamental issues. For instance, like I say, some of these sites have an owner that is nowhere to be found, and these properties are sitting in municipalities, and a check of the local records makes it very difficult to determine ownership, or some of these properties have back taxes on them or liens that also make it difficult.
Gary, I'm sorry, Michael, regarding the developers, are there is it just a handful of developers? There are a multitude of developers that look for these sites?
I think if the rules were in place, Senator, you'd have developers coming out of the woodwork, in large part because restrictions are being placed on the development of solar on prime farmland and forest land, which we understand to some degree. But we're trying to help the state meet its clean energy goals, and there's actually legislation being entertained in the Environment Committee to make the restrictions even tighter, and make development more costly and more time-consuming on forest and farmland. So if the green light was given to developers to say, move towards these brownfield sites, I think you'd see a rush, not just a few, but I think you see several handfuls of developers ready to pursue those.
Last question, Mike, have you talked to DEEP regarding the rules that you need?
We have, the rules, we've been told that there are rules in place for remediation, but it's our understanding that there are no rules in place right now to develop sites pre-remediation, or if the sites aren't going to be cleaned up. If you want to put solar on a dirty site, there needs to be rules in place, and the rules aren't there just now, and that's what we're really trying to do with this extra language in the bill.
Okay, all right, thank you, Michael.
Yes, sir.
Thank you, Senator Martin. I see no further hands raised. So I would like to thank you for being here today, and you have submitted written testimony. Michael, have you?
I have, Madam Chair, yes.
Okay, that's important. Thank you.
Very good, thank you.
And so moving on, we have with us next on deck Curtis Dukes. from the Center of Internet Security. Curtis, here you are. Go ahead. You have the floor, sir.
You bet. Thank you, Madam. Co-chairs Hartley and Simmons, vice chairs Cohen and Rochelle, ranking members Martin and Buckby, and members of the committee, thank you for inviting me today to this hearing. My name is Kurt Dukes, and I serve as Executive Vice President and General Manager, Security Best Practices of the Nonprofit Center for Internet Security, which, among other things, operates the multi-state information sharing and analysis center, as well as the elections infrastructure information sharing and analysis center. And we do that on behalf of DHS. As members, you may be aware that the ISACs provide cyber threat intelligence and other services to state, local, tribal, and territorial governments. The other portion of the Center for Internet Security is the home of the critical security controls and benchmarks, well-regarded and widely used best practice recommendations that help enterprises focus their resources on the most common critical actions to block the most prevalent real-life attacks. Before CIS, I spent my career in service to the federal government, including serving in various senior positions at the National Security Agency. I appreciate the opportunity today to share my thoughts on how we as a country can improve our cyber defenses. In way of introduction, one of those cybersecurity best practices is the critical security controls, a set of internationally recognized, prioritized actions that form the foundation of basic cyber hygiene or essential cyber defense, which is mentioned in this bill as one of the acceptable cyber standards. The CIS controls are devised based on how malicious actors attack. What results is the clearest, most definitive guidance of how to protect your organization from cyber attacks. The CIS controls are often cited as one of the tools to implement an effective cybersecurity program. To bring another level of rigor and detail to support the development and implementation of the controls, we leverage the industry-endorsed ecosystem that is developing around the MITRE ATT&CK framework. The attack model comprehensively lists attack techniques that an attacker could use at each step of an attack. Our analysis shows that implementing the CIS controls mitigate approximately 83% of all the techniques described in the attack framework, creating significant security value against a very wide range of adversary attacks, even if you don't know any details about those attacks. We believe that this bill, which would incentivize the voluntary adoption of cyber best practices, is a significant step forward in increasing the cybersecurity of our nation. We commend Representative Simmons for introducing the bill, and we respectfully urge its passage. Thank you, and I would be happy to answer any questions you may have.
Thank you for being here today. And so my question is, what are other states doing with regard to this conversation relative to the business sector? You know, we've had these conversations about government cyber firewalls and the like. What's going on in other states with regard to business entities?
Yes, ma'am, that's an excellent question. And so a number of states have actually either passed legislation into statute or through executive order have created, voluntary incentivized set of best practices, many of which list national standards such as you have, as well as the CIS controls as part of that. Other states have also gone a step further, and they've created safe harbors for if you follow these standards, then you would have some form of protection within that state. And so the states are the Attorney General ruling was the state of California. The state of Ohio has both a incentivized program as well as a safe harbor established. The state of Nevada has incentivized these best practices, and their intent is to introduce legislation during this legislative cycle to also create a safe harbor for that. But it seems to be a number of states are actually moving in this direction to actually specify what the standards are and actually incentivizing businesses within their state to adopt these standards.
And I guess that's essentially what this proposal is to create those firewalls, that safe harbor that you're talking about. Representative Simmons, who is the architect of this proposal in front of us. You have the floor, madam.
Oh, thank you, Madam Chair, and thank you very much, Kurt, for your testimony today, and for all your service to our country in protecting Homeland Security and advancing cybersecurity. We appreciate you being with us today. And following up on Co-Chair Hartley's good question, I wanted to see if you could give us your sense of the cyber threat right now and how you see the landscape. I know that we've seen an increasing rise in cyber attacks across the country, particularly right now, as so much of us are working remotely and everything is online. I'm wondering if you're seeing an increase in cyber threats to states and to consumers across the country.
Yeah, that's a great question, and so if you will allow me just a few moments, and so everyone's fixated today on nation states, Russia and China. Again, primarily, you've heard of SolarWinds as well as the current Microsoft Exchange server vulnerability that's being actively exploited. I would tell you that the bigger threat is cyber gangs or criminal networks. And over the last year, as we faced the pandemic and everyone went more remote to provide production of goods and services, ransomware spiked in that regard, and that's adversaries becoming opportunistic. But what they're taking advantage of is a lack of a basic, a lack of a basic baseline or set of cyber hygiene practices that every organization should be following and being measured against. And I think that's what we're trying to do within this bill, as well as highlight, what we believe are very effective set of practices that every organization should follow. So my point is, until we actually raise the level of security to a point, then it will continue to be opportunistic for adversaries to take advantage of you, primarily criminal networks. The nation states will do what they do. They have absolutely more resources available to them. But I think if you actually pay attention to these set of standards, then organizations will actually be more effective, and you're going to raise the cost of an adversary to attack you.
Got it. Thanks for that answer. And I think, we're so grateful for you bringing this, idea and approach to us, because I think we've seen, attacks here at home in Connecticut and breaches over the past several years. And so, like you said, I think this is an opportune time that we need to take this seriously and bolster our cyber defenses. And I was glad you mentioned I think you said 83% of, if businesses or, entities adopt these, cybersecurity protocols, they have the potential to reduce attacks by 83%, which is really substantial. And I wanted to ask you, with respect to the kind of best practices and protocols that are listed in the bill with the NIST framework and the CIS controls, are there any? Do you think those are sufficient for entities to be adopting to protect themselves, or are there any other frameworks or kind of federal sector specific protocols or other best practices you think we should include in this bill?
Yeah, I would tell you, you've got the right set of standards and best practices. What I mean by that is certainly the national level standards from NIST, the cybersecurity framework. You have the 853, you have 800-171, as well as the CIS controls and the ISO 27000 series. And so those tend to be the primary standards that you would reference. There are also a number of regulatory requirements. So if you're in the e-commerce, there's a pay card standard, PCI. Absolutely, that they still have to follow that. But what I would point out, and just as way of evidence and effectiveness of the set of standards you've listed, is there was a target breach 7-8 years ago. Everyone's familiar with it, right? Yet it had recently passed the PCI audit for that. But what they had not done is they had not established an existing cybersecurity standard, right, such as such as 800-171 or the CIS critical security controls. If they had, then they would have had a mitigation for how the adversary actually attacked a target, and they probably would have saved themselves, over $300 to $400 million in just in cost and resulting from that attack from that. So to answer your question, I believe you got the right set of standards that are already there. Some folks would want to point out DoD has the cybersecurity maturity model certification. It's a relatively new set of guidance specific to DoD. I note that within the DoD there's over 300,000 defense industrial base partners, many of which I believe they're in the state of Connecticut, and so they will require that as doing business with the U.S. Defense Department. But the underlying set of requirements that make up CMMC are actually 800-171. So you have that in your bill already. So I think you're covered by that as well.
Okay, great. Thanks for that answer. And then just a final question. Do you think that this approach in terms of providing the safe harbor and liability protection is enough to incentivize businesses to adopt these, best practices? And do you think, is there anything else we can do from a commerce perspective to support businesses, whether it's maybe providing grants or kind of technical expertise on how to do this in addition?
Yeah, so in answer to your first question, yes, I do believe this is the right approach, right? So you're incentivizing businesses within your state to adopt these best practices, and then you're offering them a safe harbor should they actually have followed that guidance for that. I think what you're also going to do, and I'll admit publicly to everyone here, I'm not a lawyer. I'm the minority within this group. I'm a STEM graduate. I'm a mathematician and computer scientist by education. But what you're doing also is we're creating the basis for a standard of reasonableness or a duty of care that we expect every business to have followed. And so should there be a breach and should there be litigation for that? And so I think these are both steps in the right direction to actually do that. And then we can create what is that standard of reasonableness through the court system.
Got it. Thanks for that answer. And I really like this approach too, because I think it both, protects businesses, but also, encourages them and incentivizes them to adopt these protocols, which will not only protect their business, but also protect consumers and data security. And they've been proven to be effective. So we really appreciate you bringing this bill to us for your testimony today, and again for all your work to advance cybersecurity across the country. So thank you so much. Thanks, Madam Chair.
Thank you, Representative Simmons. So Curtis, play this out for me, okay? So we are giving a safe harbor to companies that adopt certain cybersecurity frameworks. So you're saying purchase certain systems which are more secure for their databases, right?
No, ma'am. What I'm saying is that today every business is using information technology, right? Whether it's a laptop, a desktop, a payment card system, routers, they're online from that, and so these are all individual components that make up a system for that. And so what the CIS controls does is says, these are the set of prioritized actions you should be doing to protect yourself, right? So, for example, know every asset that's on your network, both hardware and software. Know what data you have and you're maintaining the sensitivity of that data. So if it's PII data, then there are certain data privacy rights in protecting that. It's limiting the number of a number of accounts that actually have higher level of access, admin privileges for that. It's patching and configuring for that. And so basically these are a set of actions that we expect the business owner, or if they've contracted out through a third party provider, such as a managed security provider, to actually implement these set of actions to protect that network. So you don't buy the systems themselves, but you actually have to adopt these best practices in the implementation of that network.
Oh, thank you, Curtis. So it's kind of like, the lean manufacturing designation. I do certain things to have my data secure. So then as a consumer, a couple of years ago, I went to buy Christmas wrapping paper. And then I found out I had a lot of friends in Tokyo, and a lot of charges were on my account. So in that instance, if I was seeking recourse from the retailer, that retailer would have an affirmative defense that they had adopted best practices. What would that mean to me as the consumer in that situation, that action?
Right. So in the example you cite, the business owner would have done would be demonstrate that they actually did due diligence in protecting your information, such as your name, your credit card number, your address if it was mailed to you, things of that nature, and certain privacy legislation. That information is considered PII information. So what they want to be able to do is demonstrate that they've protected that information, and that they were not the source of that lost information, and that could have been through some other business in that regard. So basically, they're proving by having adopted the set of controls and actually measuring themselves against those controls that they actually are doing due diligence in the protection of the information that you've allowed them to keep for you.
Okay, so in that example, then I would not be able to go to the retailer. Then who would I go to? The platform who issued the credit card.
Right, and so that would be typically your recourse would be go to the credit card manufacturer vendor and say my information was stolen. I've only used it in these 1, 2, or 3 areas. I've checked with those business owners, and they actually have implemented the controls for that. So that's where you'd have to go in that case.
So from a consumer standpoint, does this do anything in terms of diminishing my protection when there is a breach of my information in a transaction?
I actually think it strengthens you as the consumer, right? Because now the company is actually being measured against, is being measured against a set of standards, for that. And so should there be a breach, then, absolutely, then it gets litigated in a court of law, and depending on was what they had done reasonable or not, and that's what we're trying to do with the safe harbor law for that. So in that case, I actually think it strengthens, and provides protections for your information. Should there be a breach, then it would be adjudicated in court of law.
Okay, thank you. And so then let me ask you to go on to the other side, other than advocating for this, and tell me what would be the reasons not to do this? What would be the downside?
Madam Chair, I don't know that there is a downside to this. I guess the only downside I would say it is there will be a cost incurred by the business to actually implement these controls. And so the downside to the business is that it costs them some amount of money to actually either implement themselves or pay a third party to actually implement them. So that's a downside from the business standpoint. From the consumer side, it strengthens their case. Now, I would argue that from a business perspective, that by having done the implementation, should there be a breach, then they have an affirmative argument in a court of law that they had done what is is recognized as a standard best practice for cybersecurity.
So it's not a mandate to business. We simply say that you can plead this affirmatively if in fact this happens, but we're not mandating it. So those who look at their business model and say, I don't have bandwidth to do this, I don't have capacity to do it internally, not opting to adopt this at least now.
Yeah, that's right. I mean, it's voluntary. You're voluntarily incentivizing through this bill in that regard, and so they can choose not to do it. Should there be a breach, then then it becomes the court to decide, had they established due diligence or not when it comes to protecting your information, the consumer's information.
And then does it put the retailer in a worse position that this law is on the books and they had not adopted it?
Yeah. So my personal belief is yes, that it weakens their argument because you've established what you believe are a set of cybersecurity standards for them to adopt and use. And then you further incentivize that by providing a safe harbor should there be a breach for that. And so by not adopting those standards, then yes, I believe they have weakened. They have a weaker argument in a court of law.
Okay, thank you very much, Curtis, and thanks for being with us and having this very important and quite frankly salient conversation in the world that we are in presently. And I don't see any other hands raised, sir. So with that, I just thank you for being with us and ask you, did you give us written testimony, Curtis?
Yes, ma'am, I did.
Okay, great.
Thank you for allowing me to testify. Have a great day.
Yes, thank you. And likewise. Moving on, we have Ashley Zane, who is representing CBIA today. Good afternoon, Ashley.
Good afternoon. So good afternoon, Chairs Hartley and Simmons, ranking members Buckby and Martin. My name is Ashley Zane. I'm a government affairs associate with the Connecticut Business and Industry Association. And we're here in support of HB 6607, an act incentivizing the adoption of cybersecurity standards for businesses. This bill is based off of solid and well-adapted frameworks that are currently being used in the cybersecurity industry and builds off a lot of what's being done at the federal level. This is an important piece of legislation because companies are shifting to a remote and electronic-centered world, and we need to ensure that there are protections for consumers. So it can be also really hard sometimes to quantify return on investment because ensuring cybersecurity compliance is an expensive decision for businesses. It requires staffing, technology, funds. So this is a very straightforward way to get that return on investment by allowing them to have this affirmative defense if they have in fact put in that resource. And like what was said earlier, it doesn't necessarily all have to be financial resources that go into this. There are steps that don't necessarily cost money, but that can ensure cybersecurity compliance. We do have a lot of members who support this bill, and they will also be submitting written testimony with their own suggestions that are tailored more towards their industries. But we do urge the committee to have some sort of review process for examining frameworks because we do know the digital world evolves constantly. So we just want to make sure that these standards are constantly up to date and giving the protections both to the consumers and the businesses. So with that, we support this bill, and I'm more than happy to answer any questions.
Thank you very much, Ashley. And Representative Simmons.
Thank you, Madam Chair. Thank you so much, Ashley, for your testimony today and for supporting this bill. And I thought you made some good points too about how it doesn't necessarily have to cost financial resources to adopt some of these best practices that will, protect both the business and consumers from these cyber threats. So one question I have is, have you heard from members, through your surveys and your work about, the real fear out there in terms of, cyber threats? And, is that a big concern you're hearing among your business members?
It's slowly becoming a bigger issue for a lot of our members because the world is shifting to remote. So if you're going to have individuals teleworking, you also need to make sure that their equipment is firewall proof, it's secure. We're not going to leak any confidential information, because the last thing you want as a business is to get bad press because there was a breach. So it is an increasing concern for a lot of our members.
Got it. Thank you for that. And then in terms of the approach of this bill in, adopting the safe harbor, limited liability protection, do you think that's enough of an incentive to encourage businesses to adopt this? And, if this passes, do you think the word would be, we could get the word out to businesses about this, and that this would be enough to get them to adopt these cybersecurity protocols?
Definitely. I think this is a very straightforward, easy to understand concept where you get this affirmative defense if you've done what you need to do. And the nice thing is it's all laid out in the bill of what frameworks will work. So I think it's easy to understand, it's easy to message, and frankly, it gives the protection businesses are looking for.
Got it. Thank you. And then just final question is, as so many businesses are struggling right now amidst this pandemic, do you think it would be helpful if we, look down the road to provide state grants to help businesses do this and to be able to comply with these standards? And do you have any training programs at CBIA on cybersecurity that would, help businesses as they, look to adopt these protocols?
We would definitely support grants or training opportunities that the state would provide. We have our affiliate organization, Constep, and they have a cybersecurity compliance arm. So we do a lot of work with them, and our businesses will sometimes look for them for advice and just kind of how can they improve where they're currently at. So Constep has been a huge resource for CBIA.
Great. Thank you for that answer. And thanks again for your testimony today and for supporting this cybersecurity legislation. Thank you, Madam Chair.
Thank you, Chair Simmons. I see no other hands raised, Ashley. So thanks for being with us.
Thank you so much.
Okay. Richard Hogan, who is representing the CTIC, C-A-T-I-C. Are you with us? Hello, Richard.
Hello, Senator Hartley, Representative Simmons. My name is Rich Hogan. I'm the Chief Compliance Officer for Connecticut Attorneys Title Insurance Company, or CATIC. CATIC was actually set up by the General Assembly in 1965 with a special act. We're a bar-related title insurance company. We're headquartered here in Connecticut, and I'm here today to testify in support of House Bill 6604. We do approve of that bill with the carve-out. We would like the carve-out to remain for real estate transactions and for trust and estates. I've listened to a lot of testimony about the bill today, and I think I would like to align my comments with Representative Doucette. I think he's got the best approach here. Pass this bill with the carve-out, put together a group of attorneys to look at this and revisit the issue next year. I think one of the benefits of that is we could possibly see the regulations from the Secretary of State's office, which would be very helpful to us. But we really have a problem with the process that was used to arrive at this legislation. It's our understanding that this summer, a group of the town clerks, the credit unions, technology provider, at least one national title insurance company, the realtors and the state librarian got together to work on legislation which would provide for electronic closings. And nobody from the real estate bar was included in that group. If somebody was included, I would love to hear the name from somebody, because the Connecticut Bar Association did not find out about this until January. And the real property section was never contacted. The trust and estates section was never contacted. And I mean, this legislation deals with electronic real estate closings that are conducted by attorneys. And one would think you would like to get an attorney's perspective on what an electronic closing would look like, or what the experience was during the pandemic when, as Jason Doucette said, he closed 800 loans during the pandemic, not using the emergency executive order, and with no real desire by consumers to have electronic closings. So I really think we need to go back to the drawing board on that. I think would be important to get meaningful input from attorneys who are very knowledgeable, This is their business and their what they do. So I think that would be the best way to go forward. I would like the legislation to pass. I do want to talk about one comment. There was a comment that 30 states have already adopted this, and we would be really behind the 8 ball if we waited. None of those 30 states are states where attorneys are closing loans. None of those states are in the Northeast. And at least one other attorney state, the state of Georgia, is considering a carve out for real estate transactions with their electronic closing bills. So we are not the only state that is questioning the use of remote technology for real estate closings. So
3 minutes are up, please summarize.
I'll stop my comments at that and certainly answer any questions that anybody might have.
Yeah, thanks very much, Richard, and thanks for hanging in here as this hearing has proceeded into the mid to late afternoon. So yes, we've heard the fact that the real estate bar was not present. How though, and you started to answer, would you address the testimony that we heard about the fact that we really are already outpaced on this issue, and that there are incredible mounting requests that, for example, are coming into town clerks and so forth on this, and then we've got this situation where we have uneven access, if you will, because some towns, do the e-signing and others don't.
I think the issue there was being able to record documents in a town that were executed electronically, and the representative from the town clerks is absolutely correct. That issue could be resolved very quickly without allowing electronic closings to be done in this state. That's a very distinct issue. It's really not tied to the closing itself. It's a recording issue that could be resolved with a one paragraph bill. The issue is that when you have an electronically signed document, when you print it out, that's really not the original, and so a lot of the town clerks will not allow you to record that. I think that could be resolved without opening up real estate transactions to be done online. I'll tell you, we operate in states where this is the law right now, Senator Hartley. For example, remote notarization has been allowed in Florida for a couple years now. There is no consumer demand in Florida for this. We are not seeing our title agents in Florida changing their business practices to respond to the remote online notarization. There doesn't appear to be any consumer demand for this in those states. I know the American Land Title Association did a survey about a year ago, and over 80% of consumers want to be present at the closing. They want to be sitting at a table with the other parties and with their attorneys there.
And so to that I say, and yes, I've heard this testimony or the commentary that there was actually no appetite for this even in the height of the pandemic. And if that's the case, then it seems like it's a consumer choice to be in person, to go into the parking lot, to be in whatever alternative arrangement for these transactions. So then what's the problem?
The problem is that attorneys have had no meaningful input into this whole process. That to me, that is the problem. Where was the opportunity, in this era when we can do things remotely, where was the opportunity for people to see these deliberations? What was the opportunity for the public to offer any input? Basically a bunch of industry people went, remotely behind people's back and arrived with legislation. That to me is not acceptable. That's not, why wouldn't you want to hear from a real estate attorney who's closed 800 loans during a pandemic, how this legislation would affect them? That to me is what I just can't get, I can't get beyond that.
I hear you, and we're trying to do a total vetting of this, and so that's why I appreciate you hanging in and testifying. So you mentioned that the recording, the e-recording situation is easily addressed. Have you given us written testimony?
I have. Yes, I have.
So can you quickly provide us testimony as to how you see that issue being fixed?
I certainly can. Yes, I can do that.
And just, can you verbalize that for us now?
Yes, I mean, basically, you would just need to take the provision, the provision that would allow all types of documents to be recorded in the town clerk's office. You would just pass that without the other provisions in the bill. That's basically it. What I'm saying is that's a distinct issue that can be resolved distinctly without bringing in everything else found in the legislation.
Okay, and so on the timing of all of this, Richard, you feel like we are not disadvantaging ourselves from a commerce situation?
I really don't. No, I think you should pass Rolona now. I think you should move forward with that. I think you should keep the carve out in the bill. I think the Secretary of State should start to promulgate regulations. Once we see the regulations, maybe a lot of our concerns will go away. A lot of this is, when I look at the Rolona, I want to see the regs and how they exactly look and how they fit with Connecticut law.
Okay, well, thank you. Co-Chair Simmons.
Thank you, Madam Chair, and thank you, Richard, for your testimony today. And I wanted to get your perspective on some of the testimony we heard with respect to fraud and making sure that we're protecting consumers in this process. And I think that's something that's really important. So I wanted to hear your perspective. In your experience, have you seen a number of incidents of fraud? And if so, if we did look to move towards electronic juries down the road, are there measures do you think we could put in place to safeguard the process and protect consumers from fraud?
Thank you, Representative Simmons. I think that's a really good question. I was at the Commerce Committee last year when you had a public hearing on this legislation, and I remember former Senator Bizzarro talking about a closing that he was conducting in the home of his client, and it was an elderly woman, and her son was in the room, and he got a very bad vibe about it. And he asked the mother why he was there. He spoke to the son, and ultimately he decided to not go forward with that closing because he felt that there was elder abuse going on. And what he said was that if that had been done remotely, if he'd been looking into that room through a camera, he would not have picked up on that. So I have to believe that while it's not common, certainly being with somebody it's just not the same as seeing them electronically. We know more about what's happening in their room. We can pick up on things. So I think generally any type of process that's done remotely using electronics is not going to be as safe as something that was done in person. And I'll just bring up that example of the criminal court case. You had a defendant, Kobe Harris, charged with assaulting his girlfriend in a criminal court proceeding being done remotely. And the proceeding went on for 7 minutes before the prosecutor realized that the defendant and the victim were in the same room. And the only reason why the prosecutor discovered that after 7 minutes is because the victim kept looking over her shoulder when she was asked questions. If she never looked over her shoulders, nobody would have picked up on the fact that the defendant was in the room of the person that he was accused of assaulting. And to me, that's one of the scariest things I've ever heard of. If that court proceeding was being done in person, that wouldn't have happened. It's just, it's impossible for that to happen. And once we open up ourselves to these remote online things, we have that choice. I mean, we have the risk that fraud or something untoward is going on.
Thanks for that answer. And yeah, that example is just, so terrifying to think about. And I think this is something we have to think about as we, move forward with this bill, making sure that there's safeguards in place and making sure that we're protecting against fraud, because that's, one of the whole purposes of notaries is to make sure it's a safe process. So thanks for your testimony. Thank you, Madam Chair.
Thank you, Representative Simmons. And I see no further hands raised, Richard. So having said that, shoot us an email about your proposed language with regard to the e-recording issue.
I will. Thank you, Senator Hartley.
Okay. So
Madam Chair, Senator Martin has his hand raised.
Oh, okay. So I missed that. Shame on me. I was checking. Senator Martin, my apologies. You have the floor.
Madam Chair. Just very quickly, Richard, we've heard testimony that other states have been doing this. You just gave us an example of fraud. Have you heard anything with regards to other states that have adopted this and regarding major issues?
The information I have is the 30 states that have adopted this, either the ROLONA or the Alta MBA. What I'm hearing is that consumers are not using this and title agents are not using this. And I quoted that American Land Title Association. I just think people treat real estate transactions differently than other transactions, and they expect to sit down at a table with a lawyer on both sides. And as Representative Doucette said, there are a lot of issues that come up at closings. There are issues that have to be negotiated. And they're just better done at a closing table than done remotely with a telephone and a video camera.
But they would have their choice to choose whether to do it in an attorney's office or remotely. Just seems like the biggest pushback that we are hearing is that this is the way it's always been done, and that's pretty much we should just keep it the way it is.
I don't think that's true, and I don't think that's what Representative Doucette said. I think he and the other attorneys in Connecticut were not against improving the process or modernizing the process, but we'd at least like to be invited into the table to talk about these issues, because that's a way for us to offer the expertise that we have to the other stakeholders.
Understood. Thank you, Richard.
Thank you.
Thank you, Senator Martin. And let's see, checking one more time. I do not see any hands raised this time, Richard. So thanks again for being with us this afternoon.
Thank you.
And thank you. And we'd like to move on now to Nicole Booth. Are you with us, Nicole?
I'm here. Hello.
Hi.
Hi. Good morning, Chairs Hartley and Simmons, ranking members Martin and Buckby, and distinguished members of the Commerce Committee. My name is Nicole Booth, Executive Vice President of Public Affairs for Notarize. Notarize is a digital trust provider, a platform that integrates technology with live human interaction to establish identities. We offer digital identity proofing and authentication services, including a market-leading notary public platform to allow any person or organization to get their documents notarized online 24/7. As a sophisticated digital identity platform, we do not allow for CAT or any other filters. Access to digital services is more important than ever. And at Notarize, we applaud the committee's consideration of HB 6604 to ensure it works not only for consumers, but also for attorneys, notaries, and all industries in Connecticut. The Uniform Law Commission led a multi-year process that brought together stakeholders from the government, notarial committee, and industry to discuss a collaborative model text with the safety and security of the consumer, notary, and integrity of the Notarial Act in mind. As a ULC observer, Notarize supports efforts to pass ROLONA, on which HB 664 is modeled. A key component of ROLONA is RON, which we're discussing today. While we appreciate efforts to pass ROLONA model of RON legislation, we believe there is a missed opportunity in the bill in which Section 15 prohibits a notary from performing RON for a real estate transaction. Understanding the importance of Connecticut as an attorney closing state, we do not believe that a wholesale exclusion is the best practice. RON was built with fraud prevention in mind, and with almost 31 states passing permanent remote online notarization laws have been enacted with thoughtful coordination between government and the real estate community. Understanding the need for a strong regulatory framework, the real estate community has worked to ensure RON has multiple layers of safety and security built in. This includes multi-factor authentication, identity proofing, tamper-evident technology, an audit log, which would allow these laws to be used in a secure way for many sectors across the country, including financial services, auto, legal, in addition to the real estate. We recommend amending the bill to ensure that attorneys stay involved in the real estate transactions while still making the fullest use of the advantages of RON. The global pandemic has accelerated both demand and the need for consumer business access to digital services. As such, Notarize thanks the committee for consideration of the bill and for providing leadership to the consumers and businesses in Connecticut. We look forward to being a trusted partner with you, the Secretary of State, and other leaders in Connecticut as this process continues. And if, when appropriate, we are happy to be a technology vendor resource. Thank you.
Thank you, Nicole. We welcome the presence of your enterprise in the state of Connecticut, and in particularly with regard to this very important proposal before us as we seek to be competitive, bring our businesses into the 21st century, but recognizing the challenges in terms of consumer protections, safety, and fraud, and the like. I do not see any questions or any hands raised in this moment, Nicole. So I just want to thank you for being with us. If you have written testimony, make sure that it gets filed, please.
Thank you very much.
Yes, thank you, Nicole. And so next up would be Patrick McMahon, who is from the Main Street Center and the CEO. Hello, Patrick.
Hello, Senator Hartley. Good afternoon, Representative Simmons, Senator Martin, Representative Buckby, and the distinguished members of the Commerce Committee. I'm here to speak in favor of House Bill 6606, an act concerning economic development and the renovation of historic mixed-use buildings in the state. I am the CEO of the Connecticut Main Street Center. We're a statewide nonprofit organization working to drive investment to downtowns and neighborhood commercial districts. Section 2 of the bill calls for a multi-agency task force to include housing, banking, administrative services, and economic and community development to study the impediments to the renovation of historic mixed-use buildings in our downtowns, to consider the financing tools as well as the issues related to building safety codes, and to report on recommendations. It is also to look at considering whether the state should initiate a small real estate developer training program. We have tremendous opportunities for mixed use multi-story buildings in our downtowns. The huge amount of potential for new retail space, housing on the upper stories of these historic buildings. Mixed use development is green development. It is essentially saving buildings that have already such invested energy in them. And they're also iconic. They're so important to the historic character of our downtowns. There's high demand for these type of projects for young professionals, young talent, as well as empty nesters. There's tons of positive economic impacts, construction jobs when these multi-story buildings are renovated, jobs associated with the first floor retail commercial space, and then bringing more housing to our downtowns. That is spending power for the local small businesses. It's really critically important. but there are some significant challenges to these historic older buildings. It can be some of the hardest types of redevelopment imaginable. They can be complex projects, expensive projects, and they can be risky. And in the state, we have only a short bench of developers who have the skill set to tackle these type of projects. They can be complex from a financing standpoint to understand historic tax credits and other financing programs. Many of these buildings are owned by mom and pops, people that don't have the experience or the wherewithal. And so they need to be educated and have their hands held during the process. Complying with life safety codes can be an issue on some of these older buildings. The risk that we have in Connecticut is if we don't address the impediments, we risk losing these iconic buildings. And once they're lost in a lot of our communities, you've seen it probably across the state, ends up being empty lots that sit there vacant for years, maybe end up being surface parking lots, don't add much value to the downtown. We lose a piece of our heritage, our industrial heritage, and it's a challenge. We, about 10 years ago, along with CHFA, created a program called Come Home to Downtown. We did pilot programs in 8 communities, Danbury, Hartford, Meriden, Middletown, New Britain, Norwich, Torrington, and Waterbury. We worked with property owners. We brought in an architect to identify whether the upper floors could be converted to housing, and we would have an economic development financial firm run some pro formas to determine whether it was financially feasible. A follow-up with that was we created a $1 million loan fund through CHFA and utilizing Community Investment Act, CIA funding.
3 minutes are up. Please summarize.
So here's the issue. We have significant opportunities, but there's challenges that need to be faced. Having a multi-agency task force to address these will be beneficial for the community and the state.
Patrick, thank you so much for your proposal and thanks for being here. Can you just, I know the little buzzer went off there, but tell me about this CFHA $100 million pot of money, status of it, and how successfully it has been accessed.
Yes. So I hope I didn't misspeak. It was a $1 million loan program.
Okay.
And initially we were relegated to just the 8 pilot buildings, and we've had some success in New Britain at 99 West Street, which is West Main Street, which is just a couple of buildings down from City Hall and within a quarter mile of the fast track. The upper stories were converted into 16 units of housing. The mayor was there. Anytime one of these buildings get renovated, the CEOs of the communities, they love being at the ribbon cutting. We had the commissioner of DOT there because he understands, at the time, James Rediker, he understood how important it is to have housing in close proximity to the transit. We had 28 High Street in Hartford, 1 block away from Bushnell Park, that now has 28 units of housing. However, I got to tell you, out of the pilot projects, there are some that have stalled. Again, because they're very, very complex. In Norwich, there's a building called the Reed and Hughes building that in 2017, owned by the city, they almost tore down. Historic preservationists were able to stall that, and a developer, the Women's Institute for Housing and Economic Development, was going to try to tackle it. However, they recently backed out, and it's because they were having trouble securing the financing for that building. And it's an iconic structure, again, right in the heart of Norwich downtown. So we've had some successes. We've got stalled buildings. Those are kind of laid out in my written testimony. So I'd ask that you take a look at that. We have utilized 800,000 of the 1 million. Unfortunately, we've just come to the end of the grant period for that. So we'll need to essentially find a way to secure additional funding in the future to get more of these buildings completed. The benefit of that particular program was it had a pre-development aspect to it. So we could provide $50,000 pre-development loans so that the property owner or developer could do structural analysis, some architectural, do that environmental study, whether it was hazardous materials, asbestos, lead, that type of thing. They could start to work on the permitting. And if the project was not going to be able to go forward, that loan, that $50,000 loan, would essentially be converted to a grant. We need flexible tools. That's the bottom line. There's not enough financing, and there's not enough flexibility. And I really believe that we need to bring the best and brightest people in the state of Connecticut together on this issue. It is just so complex from a financing standpoint, from a construction standpoint, from a design standpoint, that by bringing these people together, hearing from each other, and understanding that the different programs, there are several programs in the state of Connecticut, and I applaud the State Historic Preservation Office and the Historic Tax Credit Program that they run, the brownfields through DECD, CHFA's different programs, DOH's different programs. But we got to make sure that ultimately we're able to get more of these buildings completed. The ones I've mentioned are just scratching the surface. And these buildings in our downtowns, our historic downtowns, aren't getting any, they're not getting any younger. So we're going to be facing this issue constantly. So we need the tools in place. I will say that in the legislation that's proposed, that it speaks to distressed municipalities. And I think that was a tie-in to Section 1. But Section 2, with this, the mixed use as well as the small scale developer, which I hope someone will ask me a question about that, is that, I lost my train of thought. Oh, I'm sorry. There was a distressed municipalities. Thank you. Essentially, these mixed-use historic buildings are in communities throughout the state. And I know that several of you represent districts that are not distressed communities. You're not in opportunity zones, but you may have multi-story mixed-use buildings, or you might have that mill structure that's in your downtown that needs to be renovated. You're on mute, Senator Hartley, so I can't hear you.
Sorry, that was just a little protection from my dog. So on the CFHA program, so it was $1 million, what was it, like a bridge loan program?
Yes. So again, we could use it for several things. This pre-development thing that I mentioned, the 50,000, or it could be mini perm for construction loans. It could be utilized for bridging historic tax credits. A couple of other projects that I'll mention. Kitty Corner to Dunkin' Donut Stadium in Hartford is a row of beautiful historic buildings. If you've been there on North Main Street, and the San Juan Center wanted to convert the upper stories into 10 units of housing. And so we were able to provide a bridge loan for the tax credits. The tax credits come later in the game, but you still need the money into the project. So we were able to allocate a portion of that CHFA so that the construction could be done, and then the tax credits would come in later. We also are launching a work at the Berkowitz building. It's in downtown New Britain. It's right at the gateway to Little Poland. I don't know if you've seen, there's a sign that says Little Poland. Beautiful building. It'll be converted to over 20 units of housing on the upper stories. Absolutely incredible. And we're providing $330,000 towards that, utilizing the CHFA funding. I'm really hopeful that we can go back to CHFA, go back to the state of Connecticut, get that loan program reallocated with additional funding. But our partners in that, the folks that analyze the projects and do the loan servicing for us, they believe there needs to be more flexibility in that program. So we work with LISC, the Local Initiative Support Corporation, and the Hartford Community Loan Fund. LISC has provided written testimony, and I'd encourage you to take a look at that. They believe there needs to be a little bit more flexibility on that, this particular Come Home to Downtown loan program. But there may also be needed flexibility on other state programs that are in existence. One person who's been involved in these projects this morning mentioned to me that in some of the distressed communities, we've had a lot of these projects been able to move forward because of the state's commitment to affordable housing. But in some of our distressed communities, we actually need some market rate housing downtown. And to have some flexibility to utilize state funding to stabilize some of our distressed communities might be also something to consider.
Thank you very much, Patrick. Let me have some clarity though on one point. So the CFHA loan was, or pilot was for $1 million. And did I hear you say that you have drawn down 100,000 of that?
We drew down 800,000 of it.
Oh, 800,000.
800,000.
Okay. Okay. So then do you still have capacity in that program?
No, our grant time period, our term has ended. And I think here's what I want to say about this is originally we could only utilize it on the 8 pilot buildings, and some of those didn't move forward. We did then ask that we be able to utilize the program throughout the state of Connecticut. And by the time we got that commitment to do that, we were coming close to the end of the grant term. So that's why we're going to be able to utilize 800,000 of the 1 million. I'm sorry that we've left 200,000 on the table that could have been used for a project like this, but it just goes to show that some of these projects are years in the making. By the time you educate the property owner, get the developers on board, get the design going, figure out the pro formas, the different state funding programs that are available. And I will also say federal, because federal historic tax credits can come into play as well. And that takes some brain power to know how to utilize all of these different funding sources. We actually we have a terminology for it. We call it lasagna financing. It's just all these different funding sources kind of stacked on each other.
Yeah. And so for how many years was that pilot for? What was your time frame here?
Okay, we started the pilots in 2012. Again, the initial pilots were for us just to do the architectural and the economic pro formas. We didn't actually get the loan program in place till I believe 2016. And we would take on 2 or 3 of these buildings each year to do an analysis. And we've posted those a bunch of those to our website so folks can go and look to see what the architect and the pro forma was on those different programs.
So in addition, now with the federal opportunity zone legislation and then the state enhancements that we added on to that program, this seems to be contributing or and probably very helpful in the initiative regarding our urban cities and our historic properties. Have you interfaced with any developers who are actually on the ground using the OZ legislation?
Yes. So I was a local economic developer for 20 years in North Central Connecticut. So coming to Connecticut Main Street Center, I've been very committed to bringing the private sector into play. Working with municipalities and the state is absolutely necessary, but we need to have these public-private partnerships. We have to be working with the architects and designers, the engineers, the contractors, and the developers. So we do have a list of the developers that are interested in this. And this goes to another one of my points, the sort of second part of that section, which is we have got developers that will do the larger projects. They're to scale. They know that they can make some money, the number of units. Our challenge is 40 units or less, even 20 units or less, is having developers that are willing to take on those type of projects. And that's why we've suggested that there needs to be some form of training for small scale developers. We do have folks like the gentleman by the name of Avner Crone, who did the 99 West Main in New Britain. He's taken on a couple of other of these historic buildings in downtown New Britain. There's a bunch of stuff going on Wall Street in Norwalk right now on these multi-story mixed-use buildings in an opportunity zone. So yeah, now OZs just add another layer of complexity. It's an opportunity, but it's also another layer of complexity that folks need to be able to understand.
Yeah. And so I'll just conclude my remarks by saying, so coming from the city of Waterbury, and you are familiar with it, I don't know if your pilot program did a site there or not, but it is front and center in terms of historic buildings, having been the host of a manufacturing legacy known as Scoville's Manufacturing, which then created housing stock, which you talk about the lasagna layering. The housing stock was for, the owners and investors, the industrialists of the city. And then the next layer was their managers, and the next layer, their supervisors, and the last layer, their workers. And you can see the housing stocks. And in fact, they were laid out specifically that way so that people could walk to the mill. And we have some iconic row houses, and then we've got a historic boulevard where management, it's a little microcosm of the industrial legacy of this country, and in particular the Northeast. So, and I see every day what goes on with those properties and the ones that we are losing to blight and vandalism. And they've just been shuttered because, of course, and in many instances abandoned. So this particular discussion very much resonates with me. Thank you very much. But I also want to, at this moment, thank Representative Garby, who is the architect of this proposal, which she absolutely has her finger on the pulse of the urban challenges. Representative Garby, you have the floor, madam.
Hi, how are you?
Yeah. Hi, good.
I was so advanced. Thank you for coming, Patrick, and testifying. First, I want to congratulate you. This morning, the American Planning Association recognized Montgomery Mill Building and Windsor Locks, and you were recognized for your support as Connecticut Main Street. It was really exciting. Within this, can you tell me, we're talking about like a task force, what kind of people, like careers or skill sets, would we be looking for to put into that group?
Thank you, Representative Garibay. Appreciate that question. And I do also want to mention the other co-chairs of the Main Street Working Group, Representative Quentin Phipps and Jennifer Leeper. They've been instrumental in the Main Street Working Group to move this item forward. To answer your question, Representative Garibay, the legislation calls for a 15-member task force. 4 members would include agency reps of DECD, housing, banking, and the Department of Administrative Services. You may wonder why Department of Administrative Services. I believe, the building and fire code officials would be under DAS, and that's a really critical aspect of what we need to achieve. Banking is incorporated because private sector financing is absolutely going to be critical to move a lot of these projects forward. This request is not just about state funding programs. We need to marry state funding programs and leverage private sector dollars. That's the important thing about this. So for instance, the state historic tax credits, they leverage significant private sector dollars each year. But some of the other types of representatives I believe could be useful here is like a for-profit developer. That could be like a Spinnaker or something along those lines. A nonprofit developer like the Corporation for Independent Living. You'll see testimony from Kent Schwendy, who's the president and CEO of that organization, and he would be phenomenal on a panel such as this. Tax credit expert, both federal and state. An architect representative, could be from like Cross Key Architects or another firm that specializes in historic preservation. A housing finance consulting consultant who has some experience in affordable housing as well as market rate housing. Potentially a rep from the Capital Region Development Authority. Mike Freemuth and his crew have been very successful in moving the needle on projects such as this. It's not in the legislation, but CHFA, a representative of CHFA absolutely should be included in a task force such as this. You'll see testimony from Connecticut Conference of Municipalities. They are supporting this legislation, and they suggest that there should be local representation. What I would suggest included there would be like a local building official, because the state building official and local building officials, they have to coordinate with each other on these type of projects. So having a local building official could be really beneficial. A bank representative that does commercial and residential financing. That goes to one of the challenges in these type of projects is we've got some programs that like to loan only to housing developments, and others that will only have programs that deal with the commercial. And so having that mix makes it a little bit more challenging. We have things called community development financial institutions, CDFIs. I believe we're going to hear testimony soon from Cal Vinyl from the Corporation for Capital for Change, who was in this space. Someone in the economic development analysis role, like a Goldman and York, who knows retail consulting, because that first floor commercial is just going to be critical. And then maybe a building construction contractor. That just kind of gives you a synopsis of all the different skill sets that are necessary to move one of these complex projects forward.
Right. Well, thank you so much for that. I have to say the Montgomery building is incredible. It's an incredible example of what we can do. And the more that we can save these old buildings, they're beautiful. I mean, it's beautiful. And 60% of it is income-based. And things that people said wouldn't work, it all worked there and it all came together. So thank you for testifying. Thank you for your work in our communities.
Thank you, Representative.
And kudos to you, Representative Garibay, really on your advocacy for this. We really are appreciative of that. Co-Chair Simmons.
Thank you, Madam Chair, and thank you, Patrick, for your testimony today and for all your work at Connecticut's Main Street Center. And also want to echo Senator Hartley's sentiments and thank Representative Garibay, Representative Phipps, and Representative Leeper for their leadership on this bill. And, Patrick, I wanted to get your perspective on just, overall the state of our main streets in Connecticut. We know they've been hit especially hard by this pandemic, and wanted to hear your perspective on what you're hearing out there from business owners, from towns, from our main streets in terms of the damage and what we can do to help them recover.
Well, thank you for that opportunity, Representative Simmons. I will point you to just yesterday, I did a interview with the Connecticut Conference of Municipalities, gave a full rundown of the state of Connecticut main streets, the impacts of the pandemic on our downtowns, the challenges our small businesses have faced. The restaurant sector was hit significantly. The hospitality sector hit significantly. Our live venue, the theaters, the music venues hit dramatically. Thankfully, both the state and federal government did provide various relief programs, and we've done our best to communicate with the communities across the state, with our partners, to make sure that the small businesses and the property owners knew exactly what was available and when. I will tell you, for anybody who's on this, you need to let your small businesses know to tap into the payroll protection program. It's ending March 31st. It may get extended. The way I look at it, let's bring as much of those federal dollars back to the state of Connecticut. We are, I think, an exporter of our tax dollars to the federal government. Not as much comes back to us as some other states because we are a wealthier state. If our businesses can tap into PPP, that's absolutely critically important. I'll also mention that we have a robust small business technical assistance network, and that is the Connecticut Small Business Development Center. We've got the Women's Business Development Center, Fran Pastor's group, the Senior Corps of Retired Executives have chapters around the state, the Entrepreneurial Center at the University of Hartford. All of those are combined with financial programs, regional revolving loan programs. I think that the challenge, Representative Simmons, is we have plenty of different programs that we need to be able to just continue to communicate those to the municipalities, who can then provide those to their small businesses so that they can thrive going forward.
Got it. Thanks for that answer, Patrick. And do you think with, restaurants opening up at full capacity tomorrow and, things starting to reopen, are you expecting a rebound for, downtowns and our main streets, and anything you think we can do to help, encourage that recovery?
Absolutely. There's no doubt that having higher capacity in the restaurants is going to be critical. I know that there's bills about outdoor dining and ensuring that some of the flexibility that's been present during the emergency portion of this gets extended beyond the governor's emergency powers. And the reason being is it's going to take some time for these restaurants to recover. It's not going to be overnight. We will need at least through the end of 2021, if not going into 2022, to provide that type of flexibility to the restaurants so that they can improve their bottom lines and hopefully bring back staff, slowly come back to full employment. I believe people are just waiting for this vaccines to get their vaccines to once again be able to go to our downtowns, go to the restaurants, go to events in our downtowns. People are just so waiting to do that, and it's critically important for just the social value in each of our communities to be able to have those events on our town greens and the parades and everything else.
Absolutely. Well, thanks, Patrick, for your testimony today and for all you do to support thriving downtowns and main streets.
Thank you, Representative.
Thank you, Rep. Simmons. Senator Martin.
Thank you, Madam Chair. Hi, Patrick. Thank you for coming today. Patrick, just a few questions regarding, you said that in the pilot program that there were 8 buildings, or were they all completed?
No, they were not only all completed. In fact, only 3 of them proceeded. So others, for instance, the owner decided not to move forward. In others, they haven't been able to secure the financing. The Reed and Hughes in Norwich, they didn't secure the financing. I point in my written testimony to 21 Colony Street in Meriden. I hope folks have been able to go down to downtown Meriden and see all of the work that has taken place around their town. They've created this incredible town green. There's a new stop on the Hartford line, and 21 Colony Street is a multi-story building right next to the train station, right next to the train station. They made application to Department of Housing programs, I believe CHAMP and Just in Time, and were not funded. And it was because of the number of applications that were received for limited funding, I believe, is why those didn't move forward.
So Patrick, out of the 3 that were completed, how many units were in there?
So over 30 units in the Brown Building in Senator Hartley's hometown there of Waterbury, that was utilized for UConn Waterbury students. Very important project. 16 units in downtown New Britain, 28 units in Hartford.
About 74 units. There were 5 other buildings. You talked about the pre-development costs. Were there pre-development costs associated with those 5 that were undeveloped?
Yes, we did provide some pre-development. We gave a $50,000 pre-development loan to help stabilize the Reed and Hughes building in downtown Norwich. That was packaged with a loan program from Preservation Connecticut, and was also packaged with some loans from the local initiative and grants, I believe, from the local initiative support corporation. The fact that the Women's Institute has backed away from that it puts all of that stabilization dollars at risk. I don't anticipate that we will receive that $50,000 back. So yeah, we've made a couple of investments that unfortunately we will not see a return for.
Yeah, that does. I realize that does happen. So back in 2012, is that when the $1 million was funded? Or
No,
was that funded later on?
That was funded later on. I think in 2016 we
So
started that.
1 million.
Yes.
1 million.
Yes.
How much was funded in 2012?
Okay, so from 2012, when we were doing the initial pilot programs, CHFA was funding Connecticut Main Street Center. We got a couple of grants of $250,000 to work with those architects and the economic pro forma firms to complete those studies for those.
So you said a couple, so that's $500,000?
Approximately, yeah.
You also mentioned that some of the loans, when you begin all of this, are they loans or are they grants?
So the Come Home to Downtown, it's a loan program. The only portion that could be converted to a grant is that pre-development loan.
So basically,
aspect at the 50,000.
Those are
If you came in and asked for a bridge loan, that would not be forgiven.
So out of $1 million, how much you got? 200,000 that is sort of not used, and then you got 600,000. How much of that were converted to grants?
So I believe 150 will be converted to grants.
And what's the criteria for getting it turned into a grant?
That the developer or the property owner needs to go to our loan servicer, the Local Initiative Support Corporation, be able to explain the rationale as to why the building is not feasible to move forward because they can't access the financing, or there was some other challenge related to the project.
So it's part of the 5 buildings that did not get developed, basically.
Mhm.
Okay. All right, so you've got basically 450,000 that was actually converted into loans. Is that how I see it?
So we provided $220,000 for the San Juan Center in Hartford, and that is an active loan. We are providing the $330,000 that's going towards the Berkowitz building in New Britain. We provided a $50,000 pre-development loan for Avner Krohn's building in 99 West Street. He paid back that funding, which went into the revolving loan program. We provided $50,000 for a project on Albany Avenue in Hartford at 690. That was not part of the original pilot buildings. This is when we were able to expand it beyond that. And so that's likely to be forgiven. We provided a $50,000 pre-development to 28 High Street in Hartford, that building I mentioned, a block away from the Bushnell, and that was paid back. So some of it was successful and was paid back, and we were able to put that money back out onto the street.
And is it CHFA that handles both loan processing and?
No, so we established the program with CHFA. They were the funding source. We draw it down when we need it, and then essentially we provide it to either LISC, Local Initiative Support Corporation, or the Hartford Community Loan Fund. Those are our 2 partners from a loan servicing, underwriting and servicing aspect to it. Senator Martin, I will mention that this loan program only just like scratches the surface of the total cost of all these different projects. So it is very beneficial, but ultimately the total allocations of programs are going to be way beyond our Come Home to Downtown program.
So Patrick, are these primarily rentals, or are these condominiums? Are they, what type of ownership are these?
Every project that's been proposed to date have been rental units, apartments. And some have been, most have been market rate. And when I say, market rate in some of these distressed communities, market rate can mean that they are affordable.
Last question, has there ever been an audit?
We have an annual audit. The Connecticut Main Street Center has an annual audit of our programs, yes.
And these, sorry, but the 600,000 out of that, you've got performing loans. Are all the loans performing? Are there any deficiencies?
So outside of the pre-development, the only loan that's currently operating is for the San Juan Center, the $220,000. And yes, that loan is being paid.
All right, so I'm confused a little bit. So you have 600,000 out of the 800 that are loans. And are they all, how many loans is that equivalent to? I'm looking at 3 projects here. Some of the loans have been paid back. Some of them are, I guess, ongoing. How much money do you have, I guess, currently?
We are in the process of drawing down $330,000 that will go to the Berkowitz building.
Okay, so that's not completed yet. Okay.
Yeah,
so
that has not gone to closing yet, Senator Martin. It should go to closing within the next 30 to 40 days.
Okay, so you have assets in loans that you are currently managing, someone is managing,
Yes.
and who are those? Who are those?
Who's managing it, or which are the projects?
Yeah, the loan. Who's managing the loan?
So it is, we're ultimately responsible, but we have partners in the loan servicing. And so the $220,000 San Juan Center loan is being serviced by the Hartford Community Loan Funds.
And what about the other ones?
The $330,000 Berkowitz loan will be serviced through the Hartford Community Loan Funds.
Okay.
Some of our pre-development loans that are still on the books and haven't been converted to grants are being serviced by the Local Initiative Support Corporation. We have another building in Waterbury, Senator Hartley, that's very close to the police station on, I believe, is it Chestnut? It's a small mill building that's being converted to residential. And we are providing a $50,000 pre-development loan. And that is an active loan, Senator Martin. At this point, that would not be converted because they are moving forward currently with the project.
Yeah, I realize, Pat, that a lot of this development takes sometimes a few years to get, once you got the idea, and then you start the process, and then finally getting all the stack of money available, and then putting a shovel in the ground, then the construction. It could take 2 to 4 years very easily. So thank you for your answering my questions so much. All right.
Thank you, Senator.
Okay. Thank you, Madam Chair.
Thank you, Senator Martin. And I'm not seeing, hold on, let me do a double check here, any other raised hands for you. So Patrick, thanks very much for walking through this with us in such detail. And once again, thanks to Representative Garibay and bringing this before us. Thank you.
Thank you.
So next up is Christopher Edge from the town of Berlin. Are you still with us, sir, Christopher? Yes.
Yes, I am.
Good afternoon. You have the floor.
Thank you very much. Yes, I want to say thank you to my Mr. McMahon. Great guy. We actually joined the Connecticut Main Street program recently. Very knowledgeable. It's a great program. Again, my name is Chris Edge. I'm the Economic Development Director with the town of Berlin, an advocate of creative use and reuse of properties, as well as non-traditional solutions to help communities move ahead. Speaking today on Bill 1038, an act concerning brownfield remediation. With support of this committee, Governor Malloy and Governor Lamont, the state of Connecticut has invested close to $500 million into brownfield assessment and remediation in the last 10 years. This has brought many properties from blighted and vacant to vibrant and again paying taxes. Bill 1038 would continue and expand the tools that both communities and state of Connecticut have care of the redevelopment of brownfield properties to the abandoned brownfield cleanup program. The tax credit, the 6-month period after purchase to enter the program, as well as the ability to lease a property while entering and working within the program are steps to continue the progress. This bill would allow a party who is interested in redeveloping a property but not willing to get into the chain of title to proceed in a brownfield property. The additional time under a lease, they can do investigation to determine the feasibility of the concept as well as look into this and other programs. We happen to have 2 projects in Berlin, both of which are brownfield related and have over $100,000 owed in back. Under current ownership, we have not seen, nor do I expect to ever see, any taxes. The group has the ability to do due diligence under a lease period as well as that 6-month period. I think there's a good shot there's a substantial increase in opportunities. I know firsthand that the brownfield programs have been vital right in Berlin. We have a $17 million mixed-use project that'll be breaking ground on Monday. 76 apartments and 19,000 square feet of commercial. And the reason that's happening is brownfield monies and support from the state. I would ask that you bring this bill forward as a positive step for the state, our 169 towns, as well as the development community that is eager to work to redevelop properties in our state. Thank you for your time, and I will take questions as well.
Thank you very much, Christopher, and also for leading up the economic development arm in your town. So I'm just curious, in the town of Berlin, how big? What's your population?
20,000 people.
So you are a great case in point with regard to the fact that the Brownfields program has reaches in all sectors of the state of Connecticut, large, medium, and small. And in view of our Northeast legacy of manufacturing and industrialization, these sites, as we heard earlier, somebody speculated maybe 12,000, they span the map. And so in the town of Berlin, I'm very grateful to hear about the access to this program and hopefully its future applications in your town. And thanks for appearing before us today, Christopher.
I'm more than happy to.
I don't.
If I could just add one thing, Senator, the town took a property. Sorry, town took a property that had some major contamination. With the assistance of state monies, we will now have this project. Without the state monies and support from DECD, OPM, and others, and this body, there's no way this private developer would be investing $17 million in our downtown. So I can say for certain, community of our size, it has been vital to have those monies. And yes, we've applied for more assessment monies to take a look at these two sites that are underwater tax flows.
Yeah, and that's why this is such a case in point on this program, because a lot of times, at first blush, you think, okay, it's for large urban areas, but New England and in particular Connecticut, being so storied in manufacturing, it's really spans the entire state. So I don't see any other hands raised, Christopher. So I just want to thank you for being with us today and hanging in there. Thank you so much.
Thank you all, and thank you so much. Keep up the great work.
Thank you. And so next we have Calvin Vinyl, who I'm not sure is actually with us at this point. And if not, then we are going to move on to Suzanne Walsh. And hello, Suzanne.
Hi, thank you, Senator Hartley. Thank you, Representative Simmons. I'll keep my remarks brief. I did submit written testimony, and that is in support of House Bill 6604, which is the remote notarization bill. I'm here as one of Connecticut's Uniform Law Commissioners. I also should mention that I chaired the Uniform Electronic Wills Act, which is not before you by any means, but that's why I have some familiarity with remote notarization. So I mentioned in my testimony the number of enactments, and a couple other people talked about 30 enactments, 40 expected. And I wanted to just explain, the Uniform Law Commission was actually slow to promulgate or approve this act. We approved it in 2018, but there was such impatience and desire and demand for it that the mortgage bankers and the Land Title Association issued their model act the year before. So whenever folks talk about the number of enactments of this, it's the combined total of those two products, which are functionally similar, but slightly different. The other thing I wanted to mention is I heard a couple people talking about the carve out. I'm not going to talk about that. That's a policy issue, not for me to delve into. But one of the carve outs is for wills. And actually, it doesn't matter whether you carve wills out or not, because right now in Connecticut, we don't have an act. Our Wills Act does not expressly validate electronic wills. Wills have to be written and signed, and until a judge decides that that means electronically written and electronically signed, or we have a statute, one cannot safely present an e-will to a client in Connecticut and have any confidence that it's a valid will. So wills aren't a thing yet. We spent 2 years on our Uniform Law Commission Electronic Wills Act, and hopefully we'll consider it soon. But you just can't do that now. The Uniform Electronic Transactions Act does accept wills and most estate planning documents. They cannot be electronically signed under UEDA, which we have enacted in Connecticut. So you have to fix that if you want to. We won't have e-wills regardless of what you do in this Rulona Act. However, if you enact Rulona, that would allow a vendor an e-wills vendor, a remote notary vendor, to route the remote online notarization work to somebody in Connecticut, as long as the person signing the document signs it in another state that recognizes that document. So there is some advantage to doing that. Last thing I wanted to mention is I had heard that some folks had objected to applying a Rulona to lawyers. Now, what the Secretary of State did, which is perfectly fine, is they took the remote provision and they said, we're not going to limit that to notaries public. We're going to apply it to notarial officers. And in Connecticut, all lawyers are notarial officers as that's defined. And that's perfectly fine if you want to do that. It doesn't matter to the Uniform Law Commission. That's not what the drafting committee chose to do, but that's fine. And in fact, that's what New Mexico just did. They decided that they would permit all attorneys to perform notarial acts, including remote notarizations, and they just left the supervision of the lawyers to whoever's supervising the lawyers, and then whoever's supervising the notaries, Secretary of State, supervises the notaries. If you don't want to apply the remote notary provisions to lawyers, if you're concerned that the supervision needs to be worked out, well, that's easy. All you do is change notarial officer back to notary public in Bill Section 15C. You go back to the uniform language, you revert back to that, and then only notaries public can conduct remote notarizations. That's no big deal. Lawyers can be notaries. So if I, as a lawyer, want to conduct a remote notarization as part of my practice, all I have to do is become a notary. Easy peasy, either way is just fine. So again, we would encourage the committee to approve Rulona. The Uniform Law Commission thinks it's just great. I'm happy to take any questions or route them after this hearing to the much smarter folks than I at the Uniform Law Commission office in Chicago. Thank you very much.
Well, Susan, thanks for being with us and thanks for hanging in. And I want to harken back to probably one of our first conversations when this committee, what was it, when the lights went out, everything, all these dates begin to conflict amongst each other. But I think it was actually 2 years ago, if not 3, that we started this conversation. And the truth be known, at that time, we really didn't even have, the Secretary's office on board with us. And of course, at that time, Representative Cummings, herself an attorney, was chairing our initial working group. And then, of course, when the lights went out and the executive order was issued, all of a sudden we began to see the code being cracked on this subject, and more people recognizing the benefit of this. Anyhow, having the executive order as a frame of reference, and we're now, hopefully going to all be able to stand back up our business operations and so forth. We are trying to do this in the most prudent way, recognizing all of the important input that has come from the various sectors that this encompasses. And your work as a commissioner on the Uniform Law Commission is very, very important. Suzanne, did you give us written testimony on this?
I did, and I just realized the one thing that, it's very short. I did submit it. One thing I should let you know, the Uniform Law Commission was asked to produce language that amends Rulona to do what some states want to do and adopt these executive orders, which did not encompass RON, but encompassed RIN, which is remote ink notarization, which is different. It's very sort of non-tech and it's archaic, but it's what we needed to do to get through the pandemic. If that appeals to anyone in Connecticut, and frankly, I don't know why it would, because again, it's archaic and there's lots of paper and exchanging and stuff like that. But the Uniform Law Commission is going to have that ready for anybody who likes that idea. And they have language that's not quite done, but they'll cough it up if asked. So if that appeals to you, Senator Hartley, let me know. I can ask them for that for you.
Well, okay, thank you. That's an incredible resource. But I guess I would like to, and I haven't had a chance to look at your testimony, Suzanne, but I guess I would just like if it's possible in, a quick turnaround for you to give us the language which would deal with this notarial situation, regarding attorneys.
Sure.
And yeah.
Actually, all you need to do, and I can email it to you. What the working group did is it changed. It is your bill section 15C is in caret. You use in that bill the word notarial officer. That includes lawyers. So if you don't want to include lawyers, if you want to limit the remote notarizations to notaries public and just have it limited to that group, all you do is revert back to notary public there.
Okay.
And then you've effectively carved out lawyers who are not also notaries. So if I'm a notary, of course I'm subject to the same regulation by the Secretary of State. And I think that solves that concern that, oh, it's too confusing. Well, if I'm a notary, I'm a notary. So I think that works.
Okay. Let's see, Suzanne, are there any other questions? I do not see any hands raised. So, and I'm assuming that on your testimony, we have your contact information
I
as
put it at the
well.
bottom. Yep.
Okay. Okay. All right. Thanks. Thank you so much for
Thank you.
being with us here today as we wade through this somewhat confusing notarial jungle. Thank you, Suzanne. And Heather Lang is next. Are you with us, Heather? Oh, yes.
Yes. Thank you very much for everyone's time this afternoon. My name is Heather Lang, and I'm the Vice Chair of the Estates and Probate section of the Connecticut Bar Association. I am testifying today with respect to HB 6604 versus 6605, which I testified with regard to on Monday, and that is the archaic version of the act that Susie Walsh was just discussing. With respect to this 6604, we as a section have significant concerns about the adoption of this legislation in its current form. We do not oppose the advancements of technology, as someone previously testified that we were doing, but rather that we ask that such advancements be carefully thought out and that practitioners such as our group be allowed to participate in the process. As mentioned in Rich Hogan's testimony earlier, practitioners from the estate bar and the real estate bar were not a part of that working group on the issue. And we've been the people on the front lines working with the remote notarization issue for the past year and have obviously something to contribute to the discussion. As Susie just mentioned, this act with the carve out would not apply to wills. And actually, even with the, if 15J were excluded, this would still not apply to estate planning documents such as wills or powers of attorney. And that's because those documents actually require that the witnesses be in the presence of the person signing the document, the testator or the principal. This act would just allow the notary to be distant and remote. And we think that having 15J included in the statute is important to highlight that distinction for everyone. We don't want people to think that they're validly signing a document when the witnesses are not physically present with the testator. We want that clarification. Any document, the validity of which may be called into question after the death or incapacity of the signing party may require these different rules. We need somebody to be present watching someone sign this to know that there is not fraud or duress in the execution of these documents. And that's the purpose of the witnesses. The notarization of their statements, the witnesses' statements, is just to certify and subscribe to what they would be testifying to in a court of law about that execution. We are also somewhat concerned about a provision in Rolonia that would allow people in Connecticut to have their documents notarized by notaries who are not physically present in the state of Connecticut and are not actually sanctioned or supervised by the state law of Connecticut. There are provisions in 15 which allow international notarizations foreign state notarizations, and that the party having their document notarized does not need to be here, or the notary does not need to be here. And we are concerned that that would cause a plethora of problems in admitting wills and other documents to the necessary parties. In short, we are willing to work with whomever asks our assistance to help make these laws work for everybody, and that they work for the party for whom they're intending to benefit. We're sure that with some modifications that this act and others would be able to help the elderly, the homebound, and those with a limited mobility for which we are trying to provide assistance.
Thank you. Thank you very much, Heather. Did you provide us written testimony?
I did,
on this?
yes. I did, yes.
Okay, all right, that's very helpful. And yes, we have heard from your colleagues and others who are of the same position right now with regards to this. On the one hand, it is the job of this committee to thoroughly vet this. I so wish that perhaps this time when we were kind of all, siloed here, that that Connecticut Bar, Wills and Estates were at the table on this, because I do appreciate the importance of this. On the other hand, the balance is that, we see what is going on nationally, even on a federal level. And so we're going to be doing the balancing act between these two positions, hopefully for the benefit of the consumers of the state of Connecticut, and to keep our state, quite frankly, in the 21st century. So Heather, you've given us written testimony. We are going to take all of this very carefully and try to do, although we are up against a JF deadline, it's a little bit challenging, but thank you. And your presence is very important, and great. We're very grateful to have you and also your colleagues with us today.
Thank you.
I'm just checking to see that if we have any hands raised, and Heather, I see none at this moment. So thanks again for being with us. And we will now move on to Philip Burns, who somehow kind of fell in through the gaps in today's process. Are you with us, Philip?
I am indeed. Can you hear me? Can you see me?
Yes, I can see you, and you have the floor.
Great. Thank you very much. Good afternoon, representatives and people in the public, etc. I want to especially give a shout out to Pat Billy Miller and to Caroline Simmons, my own representatives and senators here from Stamford. Thank you for the opportunity to come speak. So my name is Phil Burns. I'm an attorney in Stamford. I was a Peace Corps volunteer in Ecuador and in Haiti. I therefore speak fluent Spanish and Haitian Creole. The Spanish is not too uncommon, but the Haitian Creole is very uncommon for attorneys. And as a result, a lot of people are interested in getting assistance in immigration law. And as a result of getting involved in immigration law, I've seen a lot of the abuses that take place against immigrants. And one of the really big ones is people getting notary licenses and then misusing that notary license. And if you open up the Spanish language newspapers, and to the extent that they still exist, the Spanish language yellow pages, you will find reams and reams of advertisements of people saying, notario, I will help you in Spanish. Notario is a quasi-translation. It's not really an accurate translation. I'll explain why in just a moment. I will help you with your immigration cases. I'll get you green cards and work permits and citizenship. I'll help you bring in your mom, your dad, your aunts, your uncles, and all your cousins. And they also, many of them offer assistance with divorces. In other words, they are practicing law without a license. The reason they're able to do this is in part a phenomenon that's existed for centuries, that the person who got off the boat today takes advantage of the person who gets off the boat. The person who got off the boat yesterday takes advantage of the person who got off the boat today. But the other reason is because by getting by getting a notary license, they then frequently claim that they are notarios. And notario, or the word notary, in pretty much every language outside of English, translates into something much more than it means in the English-speaking world, Canada, US, Great Britain, Australia, etc. Here we know what it is. You pay whatever it is, 50 bucks, 100, 150 bucks. You take whatever it is, 100 question, true, false test that's open book. And then you probably spend more money getting the stamp at Staples than you did getting your notary license. A notary outside the English-speaking world is almost always an attorney duly admitted in that jurisdiction. And in many countries, it's not just a regular attorney, but an attorney who has been around for a while, has enough political contacts, and has been appointed to a position in that region to be the person to approve transfers of property, any official documents, et cetera, et cetera. So a get-rich-quick scheme that many people have used is to get their notary license, not just in Connecticut, in other states as well. This is a phenomenon across the country. And then get a sign that's a foot high that says notario, or whatever other language it is, set up in a neighborhood with a lot of foreigners in it, and those people will be fooled into thinking you are not just a lawyer, but a super lawyer. Now, I did send an email to Representative Simmons and Senator Miller with a few attachments to it. And the reason I'm here today is because in looking over the proposed new legislation, I see at section 23, a new section, which I believe begins on page 21, line 500 and something.
Please summarize.
I saw, sorry?
Your 3 minutes are up. Please summarize.
Oh, okay. The Secretary of State has not been enforcing the rules against notaries who are abusing the licenses, and I hope that this committee will find ways to make this law strong enough and encourage the Secretary of State to enforce it against people abusing their licenses. Thank you.
Thank you, Philip. So basically, your concern is section 23, which is the enforcement and oversight by the Secretary of State's office on the notarial process?
That's correct. I actually had meetings, Representative Jerry Fox, when he was representative from Stamford some years ago, and I met with the Secretary of State's office and with the Notary Licensing Bureau's attorney, Bernard Liu. And Bernard said, we don't have any enforcement power. We can't do anything about this situation. And we are going to continue to issue licenses to people who are abusing it and to renew licenses of people who are abusing it, even if it's been shown to our face that they are abusing
it. This is a new part of the discussion that we have not had today, and I thank you for bringing that before us. Do you have you put a written testimony in with us, Attorney Burns?
Well, what I did do is I provided to Representative Simmons and Senator Miller a file consisting of approximately, I think, 200 letters sent to various authorities in the state of Connecticut, including the Secretary of State and the Notary Licensing Bureau, in which clippings of advertisements by notaries advertising themselves as notarios and providing legal services were sent to those authorities, including the Secretary of State's office, from 2004, I think, until 2013. These documents came into my possession, and I have sent them in as evidence that the Notary Licensing Bureau is fully aware of these abuses and appears to have never done anything.
And the oversight resides with the Secretary of State's office singularly. Isn't that correct?
I don't know that. All I know is that the Notary Licensing Bureau is part of the Secretary of State's office, and they are the ones that issue or don't issue and renew or do not renew notary commissions.
Yeah, okay. All right, thank you. Senator Miller.
Thank you, Madam Chair. Hi, Philip. Thank you for testifying before us today. Philip, so you read, Phil, you read section 23. You have, you take issue with section 23. Is there anything we can do in section 23 to make it stronger so that we can give that bureau, that division, some teeth to enforce?
Thank you for asking that question. And I want to apologize. I didn't actually have a chance to comb through it with a fine-tooth comb, but there is one word. And I think it's on line 2 or line 3 of section 23. And I don't take exception to section 23. I'm very pleased to see, at least what I thought I was seeing in a quick glance over it, that there was discussion of enforcement. But there's one word I would change. And that is at line 2 or line 3 is the word may. The Secretary of State office may do this and this and this and this. And I would change that word to shall.
Thank you for that. And so I guess what concerns me is that this is an issue that has been going on, and this isn't the first time you and I discussed this, right? And thank you for the work that you do with the that community, those individuals that are seeking legalization and citizenship. And so that disturbs me that we know that this problem it exists and we haven't done anything about it. And so people are being preyed upon. And so my question to you is, do you have any suggested language that we could use, perhaps in this bill, and I'm just saying perhaps, that we could use in this bill to put a stop to this, because it's not fair for individuals. And I like the phrase that you use, the expression that you use, those that have got off the boat are preying on those that are just getting off the boat. And so, and I know that it happens, right? And so my question again, is there any language that you have that we could use to, in this piece about enforcement, that we could also address that issue as well?
All right. Well, I imagine the staff over at the Assembly, at the Senate, can think of something more artistic than what I'm going to try to articulate right now. But I think something along the lines of any advertisement to provide immigration services, divorce services. I don't know if incorporation services falls into that category. I don't know how much that is the practice of law or not, but some sort of language, any evidence of offering these services is a per se violation and will require a 6-month suspension on the first occasion and a permanent suspension on the second. That would go a long ways. One of the big problems with this is that the victims don't step forward. You know, victims in general, in my experience, don't step forward. But victims who are immigrants, or even if they're legal, can be afraid of the system. And if they're undocumented, they're even more afraid of the system. Even though there's actually a visa that would give them a green card if they are the victim of fraud, they still won't step forward. So one of the things that Bernard Liu has said is, well, you know, unless I have sworn affidavits from X number of people saying that this notary has been doing this, I'm not going to do anything. But of course, getting people to sign affidavits is almost impossible. But an advertisement saying, I, Fred Jones, am a notario and I will help you with your immigration, even if they're not using the word notario, if they're offering immigration services, they are practicing law without a license. They've crossed the line.
So can you, excuse me, can you send something over to Caroline and I? So Caroline, as your representatives, we can discuss it, please? Okay.
Absolutely, and I did already reach out once to my colleague Shirley Pripstein of Hartford Legal Aid. She's a whiz at legislative stuff, and she was the one who put together a lot of the questions that I emailed to you for the Secretary of State. And I will reach out to her. I know what I'm good at, and I can give you conceptually ideas for legislation. I'll ask her for specific language.
Sounds good. Thank you very much. Thank you, Madam Chair.
Thank you.
Thank you.
Senator. Representative Simmons.
Thank you, Madam Chair, and thank you, Phil, for your testimony today and for being with us. And I wanted to follow up on Senator Miller's good questions, and thank you for bringing this to our attention. And I wanted to ask you, for the letters that you sent us of the complaints, about these notarios, abusing the public, I so appreciate what you're doing to, stand up and protect people from this kind of abuse. And wanted to see if, to your knowledge, have any of them been disciplined, or has there been any enforcement action taken or investigations taken at this point, at the local level, to your knowledge?
Thank you for that question. And you'll see of the 3 attachments that I sent to you and Senator Miller and 1 or 2 other people, and if you would be so kind as to enter my email and the attachments in the record for me, you'll see one of the attachments is about Jose Ortiz, a gentleman who set up a notario shop here in Stamford, and he followed strategy number 2 of being a notario. There's basically 2 strategies. Strategy number 1 is you charge about half of what an attorney would charge, and you really do try to read the instructions and try to do a good job and try to learn what you're doing. But of course, you don't have legal training. You don't have access to a lot of the information that professionals have. And there's a guy right here on Bedford Street at the corner of 4th Street, Carlos Irizarry. He's been doing it ever since I've been practicing, for 25 years. He has bought that office building on Bedford Street, and he is option number 1, the guy who tries to sort of do the right thing, but he is practicing law without a license, which, by the way, in Connecticut is a felony. That's one thing that the General Assembly and the Senate passed here in Connecticut some years ago. In other states, it's a misdemeanor, but everywhere it is not enforced. Option number 2, strategy number 2 is you charge 2 times, 3 times, 5 times what legitimate attorneys are charging. And what you do is you say, I have a cousin who works at immigration, wink, wink, which in countries with higher levels of corruption than we have here is very clear language for I have connections and I can make things happen that other people cannot happen. And what the strategy 2 notarios do is they set up shop. They're making money hand over fist for 1 or 2, maybe 3 years. Then when people start getting deported, when they don't start getting the results, they start making complaints, and those notarios will simply move 200 miles to another city and start up again. Jose Ortiz, I think, is a Stamford native, and he was charging $25,000. If I recollect correctly, it was for cases that never had any hope whatsoever. These were dead ends. I don't know if he knew it or not, but enough people finally stepped forward that he was charged with larceny, and I believe he ended up doing some time in jail. That, I believe, was approximately 10 or 12 years ago. That is the only enforcement I know of a notario, and it was because it was not just excessive, it was spectacular, and angered enough people to draw the attention of enough people to make enough noise that the police finally arrested him. Did I answer your question?
Yeah, yes, you did. Sorry, I was on mute. Yeah, thank you for that answer, Phil. And thank you again for your advocacy and all you're doing to protect our immigrant communities from this kinds of abuse. And like Senator Miller said, let's continue the discussion on this, and we want to do everything we can to address this and make sure this isn't happening. So we very much appreciate your testimony today.
All right, thank you.
Thank you, Madam Chair.
Thank you, Representative Simmons, and thank you, Phil, for being with us and hanging in. Senator Miller has a follow-up.
Thank you. I'm sorry, Senator. I just thought of something else. Phil, do you know of any other state that has laws that prevent this kind of abuse?
Any other state that has what?
Laws that prevent this type of abuse? Because you said it happens throughout the country, right? And so I was just wondering if you
Yes.
don't, that's fine.
No, there are states. New York, of course, has a large number of immigrants, especially in the metropolitan area. And I know that, every 5 or 10 years, there's a big initiative to start crunching down on them. But then, politicians and law enforcement get involved in other things, and it sort of builds up again. But yes, there are, unlawful practice of law is a misdemeanor in every state except it's a felony. But enforcement is at best, even in the best states, spotty.
Okay, now I was just wondering that notario scenario, the language change in notary. And here is that maybe some states have set up some type of, they have a law regarding the language. And
well, we do.
The language.
In Connecticut, we don't have a law, but in the notary manual, it says you're not allowed to use any foreign language word. You're only allowed to use the English language word notary, but it's still close enough in spelling to notario that you don't necessarily need to say notario. People will see it as notario, but they still use, a lot of them still use notario. Others have backed off, they're using notary, but then they're still advertising immigration. Again, I say, look at the Spanish language newspapers. You can't turn 4 pages without seeing an ad.
Okay. Well, thank you for that. And Madam Chair, thank you for allowing me to go a second time.
Yes. Of course. Thanks, Senator Miller. I do not see any other hands raised at this time, Philip. If there are any, just give a shout at this moment. If not, thank you very much for appearing and for this incredible testimony, which is the first of its kind, certainly on this bill that we've heard today. Thank you, sir.
Thank you.
I do not believe, and good afternoon or about to be good evening to you. Thank you. I do not believe at this time that there are any other individuals who have signed up, and Madam Clerk, correct me on this if there's something I missed.
You covered everything.
Okay, and so with that, I would thank all of my colleagues for their incredible endurance here today. I hope you all had a chance at some point to get some kind of sustenance and water or the like. And thank you. We will, of course, be convening on Monday, which will be our final action day for proposals that we still have not acted upon. Chairman Simmons, comments?
No further comments. Thank you, Madam Chair. Thank you, everyone, for a productive hearing today.
Thank you. Senator Martin.
Thank you, Madam Chair. Great day, everybody. A lot of useful information we learned today, and we'll go take this on to screening and see everybody back on Monday. Thank you.
Thank you. Representative Buckby.
A lot of information, Madam Chair. Thank everyone for their testimony, and we got more work to do, but thank you.
Okay, roll up those sleeves, Rep. Buckby. That's it. Okay, thank you, everyone. Have a good evening. Be well. Bye-bye.
Madam Chair.
Thank you, Madam Chair.